God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you for that rousing cry. Good morning, everybody. Welcome to the Appeals Court, November 10, 2025. Your panel today is me. I'm Greg Massing. To my right is Justice Hand. To my left is Justice Allen. We'll be your panel for all 6 cases. We have 6 civil cases today, which is kind of unusual for us. And we usually take a break after about 3 cases. If you don't know already, it's 15 minutes per side, no rebuttal. Also, we're a live bench, so we have read all the briefs and the materials, and we're up on the matter, so you don't have to waste any time with preamble. We know what's going on. And so, as I said, 15 minutes, you're entitled to use all of it, but there's no penalty for finishing early. We have your materials on our iPad, so if we're looking away, it's not because we're checking out the Patriots score yesterday or seeing what's happening with the shutdown. We're looking at your case materials. So with that, I'll call the first case, which is 25P32, Rebecca Martin versus Town of MILLIS Select Board. Sorry, I'm just getting logged in here. Go ahead.
May I proceed, Your Honor?
Yes, please.
Good morning, Your Honors. My name is Stephen Chaplin. I represent the Town of MILLIS Select Board, the appellant in this matter. This concerns a so-called dangerous dog order that was made pursuant to General Laws, Chapter 140, Section 157, back on June 23rd of 2023. The substance of that order was that the appellee's dog, a 125-pound cane corso who attacked a neighbor unprovoked on May 13th of 2023, was found to be a dangerous dog, as that term is defined in Chapter 140, Section 136A. Within 6 days of the order, the matter was appealed to the Rentham District Court. A hearing was scheduled in front of a magistrate on August the 10th. 8 days later, a written decision was entered upon the docket of the district court, and the record reflects that the appellee received notice of that decision within 8 days. 11 days thereafter, sent an email to the clerk's office requesting that the matter be scheduled for a de novo trial under Section 157F, and because that was outside the time limit of the 10 days prescribed by Uniform Magistrate Rule 5, the town proactively moved to dismiss or strike the late appeal, which the district court granted. Rather than appealing to the appellate division of the district court, challenging Judge Walsh's dismissal or striking of the late appeal, the appellee sought review in the nature of certiorari or the nature of mandamus in the superior court.
Why isn't that proper when the statute says that the decision of the court shall be final?
The statute says that the result of a de novo hearing that's actually held pursuant to Section...
Well, no, it says the decision of the court shall be final and conclusive upon the parties. Granted, it's in the same section, Section F, that says a justice of the district court shall hear de novo and appeal. But you don't have to request a de novo appeal, right? If they didn't request a de novo appeal, would the decision of the magistrate be the decision of the court that would be final?
It would be final, but it would not be reviewable via certiorari or mandamus, because the sole avenue of appealing from a magistrate decision under subsection D is to invoke the appellate right under subsection F.
But subsection F doesn't discuss an appeal of the magistrate's decision. It's essentially one of 2 prongs that a litigant can follow at the litigant's option, correct? You could skip over the magistrate's hearing if you choose and seek only a de novo hearing, or have both a clerk's hearing and a de novo hearing, but the de novo isn't a direct appeal from the clerk's hearing, is it?
I believe it is. So my reading of the statute is under subsection D, which is the appeal from the decision of the board. As the hearing authority, you have the option to go to a magistrate, or you can request that that level of review be conducted by a justice of the district court. There's language in subsection D that says one or the other. So in this case, the request was for a hearing in front of a magistrate, and that's what would happen. The parties appeared, the witnesses were sworn, testimony was taken, a rather detailed decision with findings and rulings was issued by the magistrate. It was entered upon the docket of the district court, of the Rentham District Court, and once that entered on the docket, if you read subsection D and subsection F together, there's a right to further appellate review. This time it's a de novo trial in front of a justice of the district court, and Uniform Magistrate Rule 5 says that request has to come within 10 days after the entry of the magistrate decision upon the docket.
So if the judge has a de novo hearing and decides on the merits one way or the other, is that appealable
Yes, it is.
to the appellate division?
To the Superior Court.
The Superior Court.
In that case, because...
Okay, so if the, okay, sorry, why is that in that case would it go to Superior Court?
That's because in that case, you actually have the de novo hearing that may be invoked under, I suppose it's the end of subsection D and all of subsection F. Witnesses are sworn, testimony is taken, the matter is considered on a de novo basis. That decision, which I believe is the critical word in subsection F, that decision is final and conclusive upon the parties. That final and conclusive language triggers certiorari review in the Superior Court, and that's where we have the McCabe case, the Durbin case.
But if a judge, instead of having, is requested to have a de novo review and instead says, well, I'm not going to do that because I think this is untimely, that's not a decision of the court?
It's a decision of the court, but it's not a decision of the court as contemplated by 157 subsection F. I would submit that that's a denial of a scheduling request. That's the district court policing its own docket, saying you're too late. We're not even going to schedule the hearing. And I would submit that that's a critical distinction that I do think is recognized in the case law. In our briefing, we cite to the matter of J.C. 2015 Appellate Division decision that upholds the dismissal of a late filing challenge to an order of civil commitment. You have Frankstone versus Firm. That's the Appellate Division upholding a dismissal of an appeal in a breach of contract action for lack of prosecution, which is similar to what this was, that the appellee did not timely prosecute an appeal under subset. I suppose she didn't even request it, and accordingly, you don't even get to the hearing under subsection F. Therefore, you can't have a decision under subsection F. Therefore, it doesn't ripen for certiorari review. It would go to the appellate division. The argument would be that either Judge Walsh misread the statute, or that he abused discretion in not permitting an appeal to be filed outside the 10 days.
Right, so just to complete the logic here, and we talked about this a little bit before. If there's a hearing before the magistrate, evidence, et cetera, no request for a de novo review, is that appealable to the appellate division, certiorari, or nothing at all?
Neither of the two. Only appealable for a de novo trial to a justice of the district court within 10 days of entry of the magistrate's decision on the.
So what's the authority of the uniform rules to create a 10-day time limit when the statute doesn't have any time limit?
As I think I outlined in our briefing, it's somewhat common for a court rule, whether it be a standing order or a rule of procedure, to say in the absence of a statutory time period, this is the deadline. And I think the significance of that in this case is if the statute had said within 10 days and they had missed the 10 days, I don't think there would have been any discretion on the part of the district court judge to permit a late filing. I think here there may have been. It wasn't argued, it wasn't sought. But for example, you have Massachusetts rule of appellate procedure that permits leave to file a late appeal for certain reasons. I think that could have been argued here because it's not in the statute, but I don't think the consequence of it not being in the statute is that there's no deadline. And from a municipality standpoint, that's a fairly scary proposition, that if there's effectively no deadline, then particularly in a case like this where you have a dog that bit somebody twice, breaking one hand, deep puncture wound in the other arm. The order is for humane euthanasia. You have an animal control officer that could conceivably seize the dog. So if there's magistrate review that's just kind of unappealed and hanging out there, in theory, a year later, the town could have seized the dog, could have put the dog down, and now the town's susceptible to a claim by the owner because there was no deadline on the appeal, and now they filed one. So it's a scary proposition for the municipality.
Given the Superior Court judge's decision to remand the case back for a de novo hearing, is this case ripe for appellate review, or are we in an interlocutory position?
I believe the case is ripe for appellate review. Having reviewed the ORES decision and then the 7 or so cases that are cited within the ORAS decision. I think that the real property company versus Pitt case from 230 Mass 526 articulates the standard. I think the other cases are all on point. And the question of ripeness is whether the court below has ordered further proceedings in the court below. So regardless of whether this court affirms or grants the appeal, there will be no further proceedings in the Superior Court. The other distinction from all of those cases is they all, so the ORAS case and the 7 other cases that are cited thereunder, they all concern civil cases in the district court, tort and contract cases that went through a trial, appealed to the appellate division of the district court, and there was some error of law described in the proceedings that took place before the district court. A new trial was ordered after a trial was already held. In this case, there was no trial. The refusal was to schedule, and actually, reading the ORAS case carefully, it went up to the SJC twice as I read the case, and the first time perhaps it shouldn't have gone up, and the SJC sort of addressed that in an indirect way. But the second time, there was a removal request. I suppose it's a little different than a scheduling request. Under the statutory framework, the right of appeal was a de novo trial in the Superior Court. And the party that had not succeeded at trial asked the clerk's office to remove the case to Superior Court. The clerk's office refused. That party brought a motion in the district court seeking to compel the clerk to remove the case. The motion was denied, and that denial was appealed to the appellate division. And I would submit that's an analogous fact pattern to where we are here. It was a denial of effectively an analogous request. Granted that the town forced the issue because it was a pressing issue that had public safety implications. So rather than wait for the scheduling request not to be made, a motion to be brought to compel the scheduling request, denial of the motion, that the town sort of forced the issue and brought the motion to strike. But the result of that is the same, and if we follow the ORAS case, that would go to the appellate division of the district court. In the event that the court were to get past the jurisdictional hurdle and find that the Superior Court did have jurisdiction, I would point out 2 aspects of the Superior Court's decision where I would submit the Superior Court got it wrong. The first is the conceptual framework where the Superior Court says that appellate rights can be exercised preemptively. I'm not aware of any legal authority or any statutory framework where a party can file something in a trial court, a complaint or a petition, and plead at the end, in the event that I lose, I invoke my appellate right. And that's effectively what's being claimed here. That July or late June filing in the Rentham District Court was an appeal to a magistrate under subsection D of the board's order. Should that, at that point, the proceeding in front of the magistrate hadn't even been scheduled, let alone occur. So I think it defies the clear intention of the legislature to say that an appealing party has the ability to simultaneously say, I appeal to a magistrate, and then in the event that I lose, I can appeal to a justice of the district court. My second point is that just as a matter of what the petition actually says, I would submit that it really describes the nature of the proceedings and the nature of the appellate framework in general terms. I don't think it actually intends to preemptively exercise appellate rights. And the only other points that I would point out is that there was some discussion in the briefing as to whether deference is owed to the Superior Court. I think the legal standard's fairly clear that it was de novo review here. And it was, if any deference is owed, it's to the district court. Again, the motion that was allowed by Judge Walsh, had that been challenged to the appellate division, the standard would have been, did Judge Walsh make an error of law, or did he abuse some discretion in not permitting an appeal to be filed outside the 10-day window?
In terms of the 10-day window, this is kind of odd. I mean, how would you count the 10 days? The district court notifies counsel of decision. Actually, Right. It goes in the record on, it's docketed, on August 18th, but then it's not mailed until the 26th, or they don't receive it till the 26th, which is a Saturday? How does this clock work?
This particular rule of the district court is actually, I don't want to say it's unique, but in a lot of circumstances, district court notice is effective upon receipt. This rule explicitly says that it's 10 days from the entry. So we count 10 days from the 18th. That would be the 28th. I believe the 28th was a Monday.
There's something in the judge's findings about the electronic docket wasn't available or something?
I think what that intends to say, I will tell you, I personally was able to view it electronically, although there are intermittently issues with mass courts and other electronic resources. I think what that might have been meant to refer to is that dog cases don't show up in e-filing. There are some quirks to these cases. They're civil cases, but they kind of file a different track in the district court. And sometimes the court administration finds the organization of these cases
There's
to be
a footnote
that
where Judge Halal says that plaintiff's counsel attested that the case docket was not accessible through the trial court's online portal.
If that's what the record says, I'm not in a position to dispute it. But again, the rule does say 10 days from entry.
Okay.
Thank you very much.
Okay, thank you.
Good morning, Your Honors. Jeremy Cohen for Rebecca Martin. May it please the Court. General Law 140, Section 157, it's rare and it's clear. We have been to over 125 of these hearings, and the statute, it says clearly that a ruling is final and conclusive. From there, if we were if we
It says
wanted,
that in Section F, right?
yes,
Okay, and so Attorney Chaplin's argument is that that's referring to a decision after a de novo hearing. What's your response to that? And it's right, it is in that same section.
there was a decision, and the court made the decision not to hear the trial de novo, and that was a final and conclusive decision. In fact, that district court refused our right to have one then, and is now refusing the order of the Superior Court to hold a trial de novo. The fact that we're here, this is not ripe for this court to hear. Under the Oraz case and also Anderson v. Norton, a remand order by the Superior Court, that is not final and conclusive. Instead, we should have our trial de novo, and from there, exercise whatever appellate rights exist. Now, under this statute, ordinary appellate procedure is not available. And when that happens, the appellate division says, we are not the right court to come to. That's the Rendick decision that says, stop, we won't hear that case because there's no ordinary appellate procedure under 140, 157, which is why we went to the Superior Court on a writ of certiorari. Judge Halal got it right. He recognized that timing was not an issue and that the email requesting a date for the hearing was not the same as our prior request, which was timely, requesting a trial de novo.
It doesn't really request a trial de novo. It says, please schedule a clerk's hearing on this matter prior to a trial de novo. It doesn't request a trial de novo.
Your Honor, we believe it does, because when you file these with the courts around Massachusetts are so unused to dealing with dog cases like this that you have to make it clear in your petition for review. And on the face of it, we said a clerk's hearing and please schedule a trial de novo. Those are two different things. The clerk's hearing standard is whether the decision was made in bad faith or without proper cause. The trial de novo standard is on the actual complaint. So these are two parallel tracks that happen at the same time. The statute says that the clerk's hearing essentially comes first and then the trial de novo.
The trial de novo is different from the clerk magistrate's hearing? It's not just another, just a second try at the clerk magistrate level?
It is not a second bite. It is a completely different standard. The clerk magistrate's review is very limited under the statute. Was the order of the town of Millis done in bad faith or without proper cause.
Right.
And that's the only thing that the clerk can look at. At a trial de novo, before the judge, we can present evidence from before the incident and after the incident. The standards.
Excuse me for interrupting, but you can also include information that you addressed in the clerk magistrate's hearing addressing those same questions, correct?
We can, except when we argue at a clerk magistrate's hearing, we're just looking for where the board failed to follow due process. Where at the trial de novo, that issue has already been determined. The clerk magistrate's decision is not even prima facie evidence at the trial de novo. It is a completely different hearing, a trial anew, where we can present everything, not just whether we don't even reference the board's actions, we're referencing the dog's actions, the dog owner's actions, and whether or not the dog is dangerous. So at the clerk's hearing, the clerk doesn't decide if the dog is dangerous. The clerk decides whether or not the board got to the right decision the right way.
Is there a body of case law, that says that the de novo hearing is not de novo of the magistrate, but de novo of the board?
Yes, Your Honor. We've supplied Cullinane, Durbin, Bonacci. All of those cases went to the Superior Court under a writ of certiorari, and especially in Cullinane, the court ruled that justice would be affronted to now carry out the order for euthanasia because new information was available, and not new information was available that the clerk didn't look at. It's new information that the district court judge didn't have an opportunity to look at. In that case, there were 2 dogs that were under consideration, and one of them had passed away. Just like here, there is new information. Bentley has now been alive for 913 days since the date of the incident, without incident, because Ms. Martin is properly managing the dog. And for 913 days, she has had to deal with the angst of not knowing a final decision. And that's why we're asking the court to order the district court to recognize the order of the Superior Court so we can have this trial.
Can I ask a question that's off topic from what you're discussing here, but is there an impediment, was there an impediment to your asking the district court for an extension of time to file the request for the de novo hearing?
There was no impediment. We didn't need to. Again,
But when that became an issue, was there a reason why you could not have at that point said, even though I think your decision is wrong, I think your position is wrong as to what the timing requirements are, I'm moving to enlarge the time within which I can file this petition for a de novo hearing?
Well, our motion in opposition at the time to the district court referenced why we believed it was timely. In oral argument with Judge Walsh, I did not ask for a motion to enlarge the time because my argument was that when we timely, some 60 days before we had to, timely filed the petition for review, it has to be filed at any point up until 10 days after the magistrate's decision, and we did that. And that was the basis of my argument to the judge at the district court. Basically, this is what we do at Boston Dog Lawyers, and we've learned that courts need the guidance because it's just so rare, but it is clear. And that the sentence about a party may request a trial de novo, that is a standalone, unconditional sentence. It is not at all related to the development or the result of the clerk's hearing.
Well, I mean, the statute, it's like 157D, it goes on and it says within 10 days you can petition the district court for a hearing before the magistrate, and it goes on to say what the magistrate will do. And then it says, in that same section, after discussing the magistrate hearing, a party shall have the right to request a de novo hearing on the complaint before a justice of the court. It seems like it's following, you have that hearing and then you make a request. That's, I mean, just reading it just without any knowledge, that's what it sure sounds like.
Understood. The practicality of the statute is that is a completely different sentence. The way this statute is used and implemented in the district courts in Massachusetts, but for Rentham District Court, was that it's not conditional on the clerk's decision. There's nothing in that sentence that refers you back to the powers of the clerk magistrate or Uniform Magistrate Rule 5. It's a standalone, unconditional sentence that you can request a trial de novo which we know to be anew and not anything that was raised before, doesn't have to be based on what was raised before the clerk magistrate.
Actually, it says on the complaint. What's the complaint?
The complaint, which is different from the magistrate's review. Magistrate reviews the order. How was this order reached? The complaint relates back to the animal control officer in this case, Aaron Millett, who made a complaint to the Board of Selectmen in MILLIS that this dog, Bentley, is a dangerous dog, and that she wanted the board to review the complaint, her complaint. So the judge now skips over whatever was said at the clerk's hearing. They don't even order up that transcript. Instead, it's about ACO's complaint, where she said that there was an incident 913 days ago and that she didn't believe the dog should be euthanized. She felt that good management of the dog, a fence, a muzzle, as my client's been doing voluntarily, would work. So the judge's attention is drawn back to the complaint and not the order that was issued by the board, because that's about procedural due process.
So if the magistrate had said that actually I find that the board's process was not in good faith, does there have to be? You've already requested a de novo hearing. Does there have to be a de novo hearing then?
Well, the magistrate has three options.
You said you actually asked for one already.
I'm sorry?
You had already asked for one.
We asked for,
Is it a conditional one?
it says to schedule a
You
clerk's
asked for,
hearing.
please schedule a clerk's hearing and then prior to a trial de novo. And if you had one in the clerk's hearing, but do we still have a trial de novo because you'd requested one?
Well, it depends what you mean by win, Your Honor, because a win at the clerk stage is rarely, it can be a dismissal, it can be a remand, and oftentimes it's a remand. The clerk, and so we would preserve our right to a trial de novo because we already requested it, and then go back before the board. And my brother and I just had this last Tuesday night in a different case. The remand goes back to the board, but our petition for review is still in place, as is our request for a de novo hearing, if the board doesn't respond in a favorable way. So, go ahead, Your Honor. Sorry.
What do you say to your brother's argument that in the universe that you are describing, there's an indefinite time period that's preserved by a request for both a clerk magistrate's hearing and a de novo hearing, that's basically up to the owner of the pet to request the de novo hearing, so that someone in your client's position could sit on that request essentially for the dog's entire lifetime?
I understand that, Your Honor. So there's a couple of safeguards, couple of here, because the town can always move forward to enforce its rights to enforce the order. So that's one safeguard. A second safeguard is, regardless, within 10 days after the clerk magistrate's decision, so from day one through the clerk magistrate's decision, we have to file the petition for review. Normally, while we would do what we did here, we asked the court to schedule the hearing date. The period is not indefinite, I believe, because again, it can be balanced against the town's mission to enforce the order. It does not leave the pet owner to just sit back and do nothing.
Well, it
unless,
does, in hopes that the town takes no action and doesn't understand the obligation the same way that you're describing it.
Right, or perhaps they've recognized the error of their ways in wanting to euthanize the dog that doesn't need to be. And that happens as well in these cases. The statute is rare and clear, but this is, considering everything is anew in a trial de novo, the clerks and the courts receiving requests under as a petition for review under 140, 157 tend to handle them in many different ways. We're asking the court, in fact, for a roadmap to clarify for the courts that this is the process when you receive a petition for review, because this is what's been working, but some courts just, there isn't a roadmap yet, and we're asking that this court could perhaps develop one.
I have a question for you apropos of really not the law, but you initiated the district court proceedings with a petition for review, and it looks really courty. It it looks like a court document. It says Trial Court of Massachusetts District Court, and it's got for clerk magistrate's use, date of de novo hearing. Is that your form?
No, that comes from.
Where does that come from? I couldn't find it online. Where does it come from?
just like you can't e-file this. This is not a typical civil action. There's no discovery in a trial de novo. So that form was generated by some district courts, and it's used by some district courts, which is why we put a cover letter plus that. And that form was court-generated, not by the Rentham District Court, though.
Why, given your cover letter, since you mentioned it, wasn't the reasonable implication of your cover letter that speaks, as far as I can see, only to the standard applicable to the clerk magistrate's hearing, and the request that says clerk magistrates requesting a hearing on the order, clerk's hearing prior to a trial de novo? Why is that not understood to request only the clerk magistrate's hearing and not both?
Well, for one reason, we do refer to the petition for review, and secondly, as Judge Halal pointed out, while we may have done it the right way, we may not have used best practices. So that was a failure on our part not to also raise it in the cover letter.
And on this form, and the language is on the, is that a form that you fill out, or does the language, please request a hearing prior to de novo trial, is that
is
boilerplate? That's yours.
That's our language, because we've learned how we have to address this with the court, and that we should not, as MILLIS wants us to do, file 2 different petitions for review.
Well, thank you both. This is an oral argument. It's very informative, and the case is submitted. Unless you've got a few more seconds if you want to.
Thank you, Your Honors.
Okay. Thank you both. I said that like it's surprising. The next case is 24P1179. M.A.D. versus M.D. And I guess since this is partially impounded, let's not use names, but refer to husband, wife, or defendant, plaintiff.
May I proceed?
Please.
On behalf of the husband in this case, my name is Sandy Derlin, Warner, Federico, and Ryan in Boston. Good morning, Justice Hand, Massing, and Allen. This case has a very small record, and the issues are relatively discrete. And unless the panel has questions, I just have a few remarks, which unlikely will consume my 15 minutes. The question in this case is quite simple, and that is whether the apprehension and fear that the wife expressed at the extension hearing, the 2-year extension hearing, met the objective standard that that there was a risk of imminent harm. And here, although the husband did not have to disprove the allegations, the evidence from both parties showed that there had been significant changes in both parties' circumstances since the most recent extension of the order. And in comments from the bench, Judge Curran seemed to focus exclusively on the subjective fears of the wife and not the objective, and not on the totality of what had happened between these parties.
Did the judge not also find that there had been past unconsented to sex between the parties?
Well, there was some suggestion that my client's behavior, which was certainly not appropriate behavior, particularly during the time when the initial order was entered in 2021.
Specifically, the judge found, I credit the testimony of both parties that there was, an ellipsis, forced sexual intercourse, non-voluntary sexual intercourse.
I don't challenge that finding. In fact, that was something which was not in the original affidavit. that the wife filed in 21. It was a marginal comment by Judge Swan, and it came up during that initial hearing back in 21. But the behaviors, those behaviors, I think, before Judge Curran showed that, which led to the order being issued initially and then extended by agreement, really fell into sort of the COVID period, alcohol abuse by the husband, and depression. And it's not excusing his behavior, but it certainly is sort of the basis for how that all occurred.
Given that finding, though, the judge wasn't constrained to define abuse here only as a reasonable fear of imminent serious physical harm. The judge could have defined abuse to include ongoing effects based on the past, in this case, sexual abuse. Is that correct?
It is. I don't challenge that at all. In fact, to be sure, the wife has a fundamental right to be protected, and she objected. She objectively showed that at the time she was reasonably fearful of him, the husband, based on a host of issues, including that boorish behavior where he forced himself on her while they were still a married couple. But that understandable fear that she expressed at the return date in 2024, and it shouldn't be ignored, and it wasn't ignored by the trial judge, but it really, I dare say, it really can't be the real basis for, in and of itself, nothing else extending the order, because, and that appears to what been something that the trial judge focused on. In comments from the bench, that appeared to be the main thrust of why she chose to extend it. But I think this court can look at the totality of what happened and conclude that objectively, she was subjectively fearful. There's no question about that. But objectively, I don't think she showed that there was a basis for continuing the order because of the fear of imminent harm. I understand it's part of the calculus. There's no question about that.
So what do we do then with the cases that say that where there has been physical abuse and sexual abuse, that those are fundamentally different than ones where there is just a fear of imminent harm?
I agree. That is what the cases say. Callahan says that. The McIsaac versus Porter cases say that. I think even the Vacone case says that as well. But those sorts of cases, and I have to be somewhat careful how I phrase this, those cases talk about sexual abuse in sort of with a criminality element here. That wasn't the case. Those cases talk about individuals who were convicted of essentially sexual abuse and or rape, and that is not to diminish what happened to the wife here. But when you look at the totality of what happened, I think the evidence showed that the husband did everything that he should do for himself and for his former relationship with his former wife in terms of getting treatment for depression, taking medication to address substance abuse, and whatnot. And at some point, what more can he do in light of what occurred? And that is not to excuse his behavior, but I suggest that objectively, the standard for continuing the order simply wasn't met. And although it's not to diminish what happened in the past, and maybe I'm drawing a very fine line, but I think that ultimately it's incumbent upon the wife to show an objective fear of imminent danger, and that simply wasn't the case. And I know the cases talk about, how some abuse is never sort of, it stays with you forever, to whatever the language is. And there's no question about that. And that is not to diminish what happened to the wife here. But in the totality of it, you know, the husband acted boorishly. He acted inappropriately. You know, in 2021, his behavior was peculiar, to say the least, on the night that the Salisbury police were called. There's no question about that. And nobody and I don't, and my client doesn't challenge the legitimacy of entering the order at the 10-day hearing. No question about that. And although it was continued by agreement, because they were in the midst of a divorce case and they focused their energies there and not on the 219A, they were divorced. You know, their entanglement had ended. And objectively, what more can he do to protect, to sort of move on with his life with this specter hanging over his head? And in that context—
Well, you said that you thought that the wife had the burden there to show something objective. What do you think that the wife needs to show?
Well, I think she did show that she is generally fearful of him, in part because of what happened in the past. But the question is, going forward, is that fear, does it objectively lead to a reasonable fear of imminent harm? And that's what I don't think was shown here. And that's the review that I think this court needs to undertake, because I don't think, you know, I mean, to use a trite phrase, I just think the evidence was thin as a whole. Okay, I'm repeating myself. I'm not diminishing what happened while they were still a married couple. But at some point, there needs to be an objective showing, and I don't think that was shown.
Can I ask, to what extent is Judge Curran, who's now considering an extension, bound by the prior findings of Judge Swan? So an initial order enters, and whether, you know, it seems to be based on abuse, the B, you know, there's three definitions of abuse: right. Physical abuse, serious fear of imminent harm, and then sexual abuse. And he uses the language of B. To what extent is Judge Curran stuck with that, or can she go back and say, well, there were both B and C before, and I'm finding, you know, C now?
Well, I think obviously, Judge Swan's findings are important, and to some degree, they do form the basis for the calculus at an extension hearing, but they are not dispositive, because ultimately, Judge Curran was bound to find in that moment, in light of all of the evidence, not just that one finding that Judge Swan made, the totality does not support. So yes, it's part of it's not the only.
And does she have, it's discussed a bit in the briefs, did she have the transcript of the prior hearing before her, or did somebody have it at counsel table and didn't give it to her, or what?
That's my understanding. I wasn't there. But my understanding is that the wife's attorney did have the transcript at the 2024 extension hearing, was not given to Judge Curran. I included it in the appendix because there was reference to what occurred at that time, but that was not information that was available to Judge Curran.
That's helpful, thank you.
And unless the panel has any other questions, I'll just rely on my brief.
Okay, thank you.
I appreciate it, thank you.
May it please the court, my name is Nicholas Morris, and I represent the wife who is the appellee in this matter. Despite the suggestion of counsel, respectfully, this is not boorish behavior. The wife testified at the July 2024 hearing that the husband regularly coerced her into having sex, which is unwanted. That certainly would make out a prima facie case for rape under General Laws 265, Section 22B. Further, what the husband has not addressed in his brief is, moreover, there were other incidents that are important as to the wife's continuing fear. First of which being the husband admitted at the July 2024 hearing that he affixed a serendipitous GPS monitoring device to the wife's vehicle. That was on there for 2 to 3 months. That's the type of action that requires, if the police were to do it, the issuance of a search warrant. That's a pretty severe step when the husband has already admitted to coercing her into sex on several other occasions. Further, the wife testified again at the July 2024 hearing that the relationship had deteriorated to the point where not only did she no longer sleep in the marital bedroom, she didn't sleep on the couch in the living room, she slept in her son's room who was away at college because that bedroom door had a robust enough lock to prevent the husband from coming in while drunk and standing menacingly over her while she slept, which he had done on prior occasions. Undeterred, the husband...
But that wasn't new evidence at this hearing, right? That
No,
was
it was
that
not.
was from the previous hearing.
No, it was not. But under the Callahan cases and the McIsaac cases and such, that certainly goes towards whether or not at this point in time, July 2024, she was still in fear of the husband. And we're in the sort of category of cases that deal with physical abuse rather than threatened abuse, where the pain and scars of that past physical abuse are relevant considerations for the court when making a decision to extend the order.
What do you
I
say
don't-
to your brother's argument that when you have to look through the objective lens, that there was not enough at the extension hearing now that the husband has taken the steps to address his sobriety and his mental health?
So to that point, I would say a couple things. First would be that at the time of the hearing, the husband had said his sobriety had been for about 6 weeks, although he admitted there was an occasion where he had 1 to 2 beers prior to that. The husband then went on to say that he would no longer drink because he was taking naltrexone, I apologize if I mispronounced that, which would prevent him from drinking. The judge, who was listening, and we know she was listening to the husband's testimony because she interjected several times and asked the husband direct questions about this, asked, if you drink while taking this drug, do you feel sick? The husband basically said, I don't recall, I'm not quite sure. But the judge also asked a question that I think the husband never addressed, which was, if you stopped taking this particular drug, you would thus be able to continue to drink. So I think the husband's addressing his drinking issues is commendable, but it certainly doesn't conclusively prove or conclusively dispel the wife's ongoing fear from prior physical abuse. And I think this is a particularly good case to discuss the fact that the judge, as the trial judge, is in the best position to assess the credibility of the parties. The judge, therefore, is in the best position to assess the credibility of the husband when he says he wishes his wife no harm, when he says he's not drinking anymore, when he says he never intends to see her again, or however he phrased it. The judge is in the position to assess that. Likewise, the judge is in the position when the wife testified before the court to see how she appears, her affect, her demeanor, things of that nature, to determine at that point in time if her fear of her husband is ongoing because of the physical abuse. How does the wife interact with the husband in the courtroom? This is why the judge, the trial judge issuing this order, is afforded ultimate deference on review at this court. So I think that the wife clearly made out that this is not a thin case. The judge, although disagreed with the husband's position that he would never intend his wife harm, never intended to violate the order, things of that nature, the judge didn't have to credit that. The judge could give that, even if she did credit it. The judge had the discretion to afford that testimony whatever weight the judge felt it warranted. The judge could have fully credited him and said, that does not dispel the wife's genuine fear of her husband, ex-husband, and therefore I'm continuing the order. So I think the wife did clearly meet out her burden in this case, where it is a physical abuse case, not a threatened harm case, and the judge certainly acted within her discretion by continuing the order.
Was it always a sexual abuse case and not a threatened harm case? Or did it change from Judge Swan to Judge Curran?
So I think that gets into Your Honor's previous question about whether or not Judge Curran had the transcript from the hearing.
And also whether she can extend based on a different ground than the original order.
I would argue at the outset that Judge Swan issued it on the same ground as Judge Curran when he issued the initial order because of the notation he made on the affidavit that the husband had been sexually aggressive. Now, perhaps Judge Swan could have fully fleshed out that a little bit better in his written findings. But another way to address this would be that the husband likely had the benefit of the prior hearings transcript at the July 2024 hearing and could have used that to confront the wife about have you said these things before at the prior hearings? And tried to impeach her by omission, impeach her by contradiction, and challenge the wife's credibility on these allegations of sexual assault.
It seems like actually when they got to that part of the hearing at the 2024 hearing, it's sort of nobody wants to go there. There's and I guess it's when the wife is being direct examined by her attorney. It's like kind of like I don't want to get into there, but could you just to summarize? Would you say it right? I mean, why was there? You know, right? Am I right about that? Is that a correct character? They didn't like nobody really wanted to get into it.
Right. By and large, I think that's correct. And the judge also said at the outset, I believe Judge Curran said something to the effect of, "I don't want to relitigate the prior hearing, but I understand I need to hear some of this because it may bear on what standard I am using when making my decision." So the judge at the outset recognizes the relevant legal standards that she needs to apply when hearing the testimony from these witnesses, and did so. Certainly, the Judge Curran could have elicited further information on this point, either herself or by directing counsel to do so. But again, when even the wife, as Your Honor had put it, makes sort of, I don't want to use a conclusory, but a summary statement about what had happened previously, that is why the trial court is afforded deference in assessing the credibility of the witnesses, because the wife is standing in front of Judge Curran, making these statements, offering this testimony under oath, both direct from her counsel and cross-examination by the husband's counsel. So even if, yes, Your Honor may be right, it could have been fleshed out a little bit better, that's why the judge is sitting in the room looking at these witnesses.
One more question. So if it's based on continued effects, fear, which is a continued effect of the prior sexual abuse, does that go on forever? Is there a point where 2 years, when it comes up 2 years from now, assuming if we were to affirm 2 years from now, there's another hearing, assuming that your client wants to continue the order, what's the issue then? Am I still feeling fear, does it have to be a lot of fear, or?
No, I do not think it goes on forever, unless the wife were to apply for and meet the standard for a permanent restraining order. But I think that's actually not the issue before the court. The issue is when Judge Curran heard this and when the wife said, "I am still in fear now," I believe it was 3 years later, when the judge decided that's correct, you've met the standard, I'm going to issue the order, did Judge Curran abuse her discretion making that decision? That's the issue before the court, not whether or not would this court, based off Your Honor's question, have made a different decision. Seeing no further questions, I would rest the remainder of my argument on my brief. Thank you.
Great. Well, thank you both. The case is submitted. Our third case for this morning is CORREIA versus CORREIA, 25P271.
Good morning. May it please the court. Francesca Blazina for the appellant, the father, Fred CORREIA, in this matter. The father respectfully moves this court to vacate the judgment issued by the lower court and remand the matter to determine custody and an appropriate parenting plan for the father with his children. The lower court abused its discretion and committed a clear error of law by delegating to the children's therapist the sole discretion to determine the father's current and future parenting plan. The legal issues within the judgment are twofold. First, the judge cannot delegate her judicial authority to a therapist. Our case law is extremely clear and well established that a judge of the probate court may not defer issues of custody and visitation to a third party to make binding decisions regarding a parenting plan absent both parties' agreement. That authority belongs only to the court. Specifically,
can I ask a threshold question here? Are these issues being raised for the first time in this appeal?
I believe, yes. The father below did request family reunification therapy and did request a 50-50 parenting time, but he did not indicate that a therapist would be appropriate. But therapy was actually included within the provisions outlined in the parties' separation agreement, and there was both a modification and a contempt pending at that time. So father was really seeking enforcement of the provisions regarding the prior family reunification therapy.
So when the judge issues the decision that says that the therapist will decide when the children are ready, nobody says, Judge, you can't do that.
Well, neither.
Like, motion for reconsideration or something like that. The case law says you can't do that,
That's correct. I agree with you, but it still does not allow the judge within her judgment to exceed her judicial authority to shift her decision to a third party to make decisions regarding if and when the father is going to have parenting time. The Silverman case is extremely spot on that a judge of the probate court cannot grant to a therapist specifically the sole authority to determine when parent-child visitation is appropriate. That is precisely what the judge has done here. She writes in her judgment when the children's therapist deems it appropriate in two specific sections.
What exactly was it that the father asked for in the proposed judgment?
He was looking for family reunification therapy and a continuation of the 50-50 parenting time that he had at the time of divorce.
So he wanted 50% of the time with the children, but he was agreeing to submit to therapy.
Correct. He did not file an answer or a counterclaim for modification that he was seeking any changes to the judgment. It was only mother who had filed a counter or complaint for modification and seeking changes. Father had actually only filed a contempt that was consolidated with the trial. He was seeking enforcement of the separation agreement and what the parties had agreed to, which was initially family reunification therapy with one of the children and ultimately a 50-50 parenting time schedule. And the parties did actually exercise a 50-50 parenting time schedule with the two youngest children for a year after the initial judgment of divorce entered. Specifically, the judge exceeded her authority in numerous aspects of the judgment in paragraphs 5, 6, and 7. In paragraphs 5, the father's contact with the therapist is limited, and any communication between father and the therapist is initiated by the therapist and at the therapist's sole discretion. Paragraphs 6 and 7 of the judgment are even more troubling. It is improper for the children's therapist to determine if and when family reunification.
Why is it error for the judge to limit contact between the therapist and the father?
The judge has the ability to limit and set conditions on father's parenting time, but father is essentially handcuffed now from ever seeking a modification of this because in one instance in the judgment, the judge says father may send one letter per month to the children's therapist for each of the children. In the very next section, it says father shall not in any manner interfere with the children's therapy. Any communications between father and the therapist shall be initiated by the therapist and shall be at the therapist's sole discretion. So in one instance, she says that father cannot contact the therapist, and then in the same sentence, she says, well, father may send one letter per month. So he's not included within any of these therapeutic decisions that are being made. And regardless, it doesn't change the fact that the court cannot delegate the current and future parenting plan for the father to a third party. And it essentially...
So I'm just a little confused on what you're arguing with respect to this paragraph, because I think that it's common for the trial court to put provisions in that if there's one party has sole legal custody, that there not be any communication with a therapist. So are you saying that that is the error, or are you saying the error that you believe that what it leads to is an inability to file a modification?
The latter. Because of the fact that he's not allowed to have any communication with the therapist, there's no way for him to even determine when family reunification therapy would be appropriate. He's not allowed to reach out to the therapist to determine, what the progress are. He's not allowed to have any specific communications with them. And my understanding of what has actually happened here is that there has been no therapist involved. So he's not able to go back to the probate court to file a complaint for modification.
Why is that not a contempt?
Well, it would be a contempt, but I would say that there may not be a clear and unequivocal order that he's able to enforce at that point. First, regarding the therapy and his contact.
So let's not address things outside the record, but assuming that say there is a therapist involved, passage of time can lead to a modification. If he does not hear from anybody for 6 months, a year, why can he not file a modification?
In theory, yes, he could file a modification, but the first question that a judge reviewing this is going to ask is, well, what are the children's therapists recommending?
May I ask this? Did the judge not allow the father to obtain the children's medical records, just not communicate with the therapist?
He was, in paragraph 2 of the judgment, he did have access to the children's academic, medical, and hospital and health records of the children, but he was...
Are you taking the position that that doesn't include the therapist's records?
I think the therapist records would be privileged from the father obtaining.
Okay, but there's no exception here saying, essentially this is saying that the father has access to the information about the children. There's no caveat for except privileged records or anything along those lines. That's a court order granting access to the children's records.
Sure.
Why, with that information, does that not give the father a toehold for bringing a request to have a modification based on what he sees in the records?
Well, because it's still based on a third party making that decision. It's based on whether or not a therapist deems it appropriate for a father to have supervised parenting time. And also, I would even go so far as saying it's not just the therapist that we're looking at here. It's the therapist in conjunction with a parenting, a professional supervisor selected by mother in consultation with the children's therapist. The judge essentially took her final decision-making and shifted it to a third party. I would say 2 third parties, really, in regards to the length, location, and frequency of the father's parenting time. If father goes to file a modification here, he has to prove a substantial and material change in circumstance after a complaint is filed, and the judge is ultimately the one who has to make a finding that a modification judgment is in that child's best interest. The first question anybody is going to ask is, okay, well, the judgment says when the children's therapists deem it appropriate. So what are the children's therapists saying? So it's not for the children's therapist to decide if and when the father may have access to his children. That is for the court to decide.
So how does the court know? So in this case, unlike in Silverman, the court said that I see right now that the father's custody with the parents, with the children, is not good for the children. And so she makes a finding that right now is not a good time, and something has to happen before we should restore, visits or custody or whatever. And I would like, as a judge, I would like the children to have this therapy that you requested, by the way, this family reunification therapy, and I want the kids to be ready for it. So when does the judge know it's time? I mean, doesn't the judge have to depend on a recommendation from a therapist? I mean, what are you asking for? What should have happened?
Well, what the judge certainly can put conditions and limitations on a parent's parenting time. I'm not necessarily disputing that, but what the judge did here is she clearly delegated that authority.
I understand what you're saying she did, but I said, what should she have done? If she wants the input from the therapist, should there have been a hearing every month for the therapist to come in to talk to the judge and the judge to say whether to continue the therapy or not?
Well, no, but I would say that the judge did make a finding here that father and his access to the children and his parenting time with the children was something that should be protected and that there was a need for supervised parenting time. She found in her findings that there was a need for supervised parenting time, but then in her judgment, she didn't order supervised parenting time. She said supervised parenting time can potentially happen in the future if and when the child's therapist deems it appropriate. I would say that that's not a condition of parenting time and is clearly a delegation. A conditional order would set a judicially reviewable criteria. There's no condition really to enforce, and it's really just the therapist's unilateral decision here that the court is going to be looking at. And I would say that the court essentially relinquished control by allowing the therapist to make this final decision.
So should the judge have said, I think it's important that there be supervised parenting time when the children are ready. The children are not now ready, in my estimation, so there is no supervised parenting time, and at some later time, someone can come back and revisit the advisability of supervised parenting time? That doesn't seem like
I think that could have been an appropriate finding by the judge as long as that was supported by the findings, by the testimony, by the evidence. The judge certainly could have made a decision that, mom is going to have sole legal and physical custody and parenting time. Father to father is not appropriate at this time, but at least then father would have a pathway forward to file a modification based on a material and substantial change in circumstance and have an ability to be heard by the court again. Here, the issue is that by relinquishing control to the therapist, which he did not agree to, he's kind of stuck. He's procedurally handcuffed.
So this just reflects maybe my lack of understanding of exactly how this process works, and I'm not trying to bog your argument down with this, but if the judge made that determination, right now supervised visitation is not appropriate, much though I might like it to be the case and think it would be appropriate under different circumstances. So I'm ordering no supervised visitation, no visitation for the father for the time being. I am ordering that the children participate in therapy, and I'm granting access to the children's records to the father, but the father may not communicate with the therapist. How does that advance your client's cause in this situation?
It gives him an opportunity to return to the court where the judge can make a determination of whether or not a material and substantial change in circumstance has occurred.
Why can't that happen now? I understand your argument about the delegation, but understanding that the father could say, I don't feel like the delegation is happening the way it's supposed to be happening, how is this situation different from the one that I've just described as far as the father's ability to access the court to make his case for a change?
He certainly could file a complaint for modification, but when a judge is, looking at a complaint for modification, you immediately go to the prior judgment. Okay, what does the prior judgment say? When the children's therapist deem it appropriate, the judge is going to say, that's my judgment, that's my order, that's what should have happened. Do the children's therapist deem it appropriate for, first, the parties to engage in family reunification therapy, and second, for the father to have supervised parenting time? The judge didn't even determine exactly what that supervised parenting time looks like. She specifically says, the length, location, and frequency of the supervised parenting time shall be determined by the supervisor in consultation with the children's therapist. Certainly, yes, could he file a complaint for a modification, but it's going to be handcuffed by the fact that it hinges on what the children's therapists are ultimately recommending, and that is not a determination for the children's therapist. Chapter 208, Section 28 specifically gives that authority to the judge. It is the judge who must make the final decision here regarding father's access and visitation to the child, not the children's therapist.
So then back to the question that Judge Allen's question raised for me, and maybe I just misunderstood your answer, that's entirely possible. But if that's the circumstance and what's the mechanism? How does the judge, if it were to be the judge's determination whether the children were ready or not based on recommendations made by the therapist, what should the order have been? Monthly check-ins on some other basis, some other mechanism? How is that supposed to be affected?
Sure, I agree. Yes, there could have been an order. Well, also, I think that there could have been a possibility for the parties to agree on maybe, if this was going to be what was ordered, I think that father could have had an ability to kind of be more involved with the family reunification therapy. Also, at the time of trial, one of the minor children, Camille, she didn't have a therapist. She wasn't seeing a therapist. It didn't work in the past. Family reunification therapy did not work in the past. These children, the judge made findings that this process was really not working in the past, but then hinged that process in the moving forward in the future on a third-party decision in the therapist. Did I answer your question?
Yes, I think you did. Thank you.
Okay. I would just say, just in sum, the father is not able to contact the therapist. He cannot initiate or seek the reunification therapy, and therefore he's not able to seek a modification under Chapter 208, Section 28. His access to the court and his children depends entirely on a private actor's decision and not a judicial finding. The lower court infringes upon the father's constitutional and due process rights to have the merits of his case adjudicated by the court and denies him the opportunity to be heard on a further modification. For these reasons, the judgment is a clear violation of our law based on both the Bauer decision and the Silverman decision, and I think that it should absolutely be vacated and remanded to the lower court so that the lower court judge can make adequate findings and an adequate judgment, and she can make the final decision of if and when father should have parenting time. And I would just end by saying that...
Thank you. You've been summing up for a while now, and the time's up, so I think we get it.
Oh.
Thank you.
Good morning, Justices. May it please the court, my name is Amanda Carroll for the appellee mother. This case is not why Silverman was done. This is a measured, thoughtful response to exactly what the court asked for in Silverman. This judge, after a 3-day trial with expert testimony, testimony from the parents, a guardian ad litem with an additional amended update from the guardian ad litem, decided and then detailed in 170 detailed findings the reason for each one of the things that my sister counsel has brought up. The reason that father is allowed only 1 letter a month is those detailed findings show that prior attempts at getting and maintaining therapists for the 2 youngest children were stopped or impeded by father harassing the therapists over the phone. That is why the letters are in there. When it comes to whether or not Dad could have filed a motion to reconsider the judgment, a motion for clarification on the judgment, as the justice said, a contempt if he felt that things were going on too long, or that one of the therapists was not communicating in response. If in his letter he said, I would appreciate an email or a letter back, even if the therapist understood through the reading of the judgment that there was some concern with a phone call, absolutely letter writing would have worked.
So I'm
None
just
of that has
going to
taken
interrupt you
place.
because
Absolutely.
the father is not contesting any of the findings, so we take
Correct.
those. I think that what I'd like for you to focus on in paragraph 6 and 7 is the phrase, when the children's therapists deem it appropriate, because I think that that's really the crux of the issue here, and why is that appropriate?
Absolutely. So in Silverman, the issue that the SJC had with the therapist's open-ended decision-making in that one was not just about the fact that it was as long as needed. It was the fact that the findings did not support a delay or any harm in waiting for anyone's preparedness or any clinical decision. Here, the judge articulated why it was necessary to wait until the children were ready. It articulated years of attempts at various forms of supervised visits that ended with the children regressing, having more harm, more issues, more medication, hospitalizations. She left the door open a smidge for these children to finally get the therapy that they needed. And yes, mother is required under the judgment to send father regular updates with all of the contact information. He has had the contact information for each of their separate therapists since they started that, which was less than a month after the judgment went in. And there has been no communication. The therapist is asked to do a narrow clinical role here. The issue that the SJC had in Silverman was that any delay was not only not supported in that judge's findings, but the findings themselves in Silverman showed that there was no delay necessary in mother getting therapy. Here, the detailed findings thoroughly discuss the harm, the re-traumatization, father's behavior, and the children's inability to deal with that, even in attempts at supervised visits. As for the part that my sister counsel brought up, that it doesn't go into detail as to when and how often supervised visits are. As a probate and family attorney, those are never the judge's decisions. It's whenever the supervisor can fit it into their schedule and as often as the supervisor is available. Those are always very limited. They are not like unsupervised parenting plans or supervised parenting plans with a family member. This is an employee, often through the court system, but their schedules are quite full. They determine when that schedule is. It's typically for an hour a week. Maybe it's 2 hours every 2 weeks. But that is not typical in probate and family orders. So this judge's decision did everything that the SJC asked in Silverman. She articulated exactly why that delay, even if viewed through the lens of an effective termination if the children are never ready, would be supported under Silverman, because those findings showed that years of attempts at supervised visits had shown more harm to the children, that everything was supported. And that was why. Father just wanted to keep the 50-50 custody. All of this abuse came in. The older children had aged out and have no contact. This was about the youngest two children. And they are older. They're teenagers. We are not talking about a 2-year-old that may never be ready, and this isn't even something that a clinician could determine. We're talking about teenagers that, per the judge's findings, witnessed years of domestic violence. They spent years in court-ordered attempts at supervised visits where 99% of the time they were having panic attacks in the car, and this is in the record, and they're not even getting out of the car. All of that was articulated.
The judge wants, is there something in the judge's findings or rationale that she wants to work towards supervised visits? And isn't that then, and when that occurs, isn't that in fact in the hands of the therapist and not the judge?
The clinical decision as to their readiness, yes. But just as if we ask a clinician to determine when an injured party is able to resume and go back to work, she is asked to perform a narrow clinical role. In Silverman, the therapist also had the additional ability of deciding whether or not visits were supervised or unsupervised. This therapist, the two therapists, there are two separate therapists for each of the children, are simply being able to pull the trigger and say, okay, yes, the children are ready. And I can say that with 0 letters from father, it's perfectly appropriate that the therapist sees that there is no interest. And the child's willingness and readiness to attempt reunification in a case like this is equally as important as the parents. If there is no, because the therapist got the same judgment that articulates how this is supposed to be laid out for these children. Mother has already retained a supervised parenting or parenting supervisor, supervised parenting time, a supervisor for when the children are ready. And all of that is simply stalled because there has been no communication, no interest from father, and the idea that the court door has been closed to father is absolutely not supported in the judgment or the procedure of the probate and family court. As the justice said, he could file a contempt. If he feels that he's being shut out, he could have filed a motion for reconsideration to clarify whether or not he was able, what could be included in these letters. He could file, as the other justice said, time is something that can go by. If there's a certain amount of time, that absolutely can meet the standard for a modification to open that door and say, is this actually happening the way it was designed to? And none of that has occurred. Their entire brief is that the therapist has this overarching power similar to Silverman. And this case was a wonderful judicial response to Silverman and exactly what the SJC and this court has asked judges to do. Anytime we're restricting, we're limiting a parent's access to a child, there has to be specific findings that link those decisions to the factors in Section 28 and Section 31A. This was an extensive domestic violence case, and the judge very thoughtfully listed all of those factors, backed up every one of those decisions. The father's inability to call the therapist has multiple findings linked to it. The father's being restricted to sending a letter once a month has findings.
I'm sorry to interrupt again, Attorney Carroll. At the beginning, I asked about, was this being raised for the first time on appeal, and I think I saw you nodding. Was there an opportunity to raise this before coming here?
Absolutely. As I said, a motion for clarification post-judgment happens quite frequently. when one party feels that a judgment is not quite clear as to what is expected of them. A motion for reconsideration on one or two specific issues in a judgment, very common in probate and family court, or a contempt or a modification, and there has been absolutely nothing other than the appeal.
And on the prior restraint claim, wouldn't, I mean, if they were to come to court and say, you know, it's time's gone by, I'd like to resume visitation, would your response be, no, the therapist hasn't said so yet?
Absolutely not. That's the only restraint on specifically complaint for modifications is that the bar is elevated for the first 6 months following the entry of a judgment. That is it. The door is never closed. And especially in probate and family, you know, we're always looking at the best interests of the children. In any case where children are involved, there is never a closed door. That was the key issue in Bauer.
What's your support for that 6-month rule?
Say again?
What's your support for that 6-month rule?
Glad you're asking that, Justice Allen, because I'm glad you're asking that because
It is not my rule. The court, whenever a judgment enters in a probate and family case.
What rule from the probate court says that?
I do not know it off the top of my head, but I do know that within 6 months of the entry of a new judgment, that the bar is elevated, that the change in circumstance has to be something greater than would exist at 6 months and 1 day. But the door is absolutely never closed.
So there's I'm familiar with that in DCF cases, review and redetermination, there is a 6-month thing, but is this case law, statutory law?
I believe it is a rule, and I do apologize. I do not have that off the top of my head. But as far as anything, even if it exists only in my head, that is the only bar of any kind. Because, again, in probate and family, anything concerning the welfare of the children, the court's door is always open. And father absolutely could have, immediately upon receiving the judgment, filed a motion for clarification as to what that meant. He could have filed a motion to reconsider on certain points.
So I think we've established that there was no motion for relief filed. But there has to be, if there's a complaint for modification, there has to be a material change in circumstances.
Yes.
And would your, so to sort of piggyback on Justice Massing's question, would your response be to a complaint for modification that was filed 7 months after the judgment, be that there's no change in no material change in circumstances because the therapist has not opined positively for there to be a resumption of reunification therapy or supervised visits?
Not necessarily. I believe my sister counsel was accurate. I think that the opening question would be, let's hear from the therapists and get a report from the therapists that state how this is progressing along. And then possibly the judge has the same options of a GAL or any other of the various methods to try to get a feel for if this process is happening appropriately. I would say if the shoe was on the other foot, my suggestion would have been to first file a motion for clarification to make sure that father's role was understood as far as his ability to communicate. The order does give him full access to their medical records, and he does have all of that contact info. But then the second would be that if some period of time, a few months went by, and father was sending letters with no response, then I would have absolutely filed likely a contempt, just a civil contempt, to be able to quickly get back into court and figure out, is this progressing the way that it was intended to? But this this therapist, unlike Silverman, does not have the ability to determine supervised or unsupervised visits. That is a judicial decision. This was only ever supervised. It was supervised already for 2 years before the judgment went in, and that was continued. every one of the decisions that the judgment has is fully supported in the 170 detailed findings that this judge did. And if this isn't enough to satisfy Silverman, Bauer, as well as sections 28 and 31A, probate and family judges are going to be left asking, what more can we do in these domestic violence abuse cases?
All right, well, thank you both for your arguments.
Thank you very
and
much.
the case is submitted. We are going to take our customary 15-minute break here. We should be back about 10 after 11. All right, so we are at the fourth case on the list today, which is Barrows versus New England School of Acupuncture, 24P 1449. Attorney Perilous, is that right?
Morales, yes.
Perilous.
Good morning, ladies and gentlemen of the court. I represent Leah Barrows, and I've represented her for 19 years. When I left working as a bar advocate, doing a small amount of good for a lot of people, I decided to do a lot of good for one pro bono client, and I chose a worthy pro bono client, and Leah Barrows was the pro bono client of my dreams. When I met her in 2006, she had no child support. She and her infant daughter were starving. I got her child support. She started a home business. And using the home business, she went back to, at the age of 40, went back to complete her undergraduate degree at Tufts. And she graduated from Tufts University with a Bachelor of Fine Arts and excellent grades. And I was extremely enthusiastic when she told me she wanted to go on to graduate school. And she had a lifelong dream of being an acupuncturist, so she enrolled at the New England School of Acupuncture. But little did she know what was actually going on at that school. She enrolled in the fall of 2015. The New England School of Acupuncture had just been bought by the Mass College of Pharmacy and Health Sciences, and MCPHS went in there with a sledgehammer. They weren't there to maintain the school, they were there to close it. In their memorandums, they refer to it as the Newton Teach-Out. But the short story of it is, they bought the school in 2015, and by 2017, it was shut down and dismantled. They were getting rid of a competitor. Now, there isn't a single acupuncture school in Massachusetts. And now if you want to get any acupuncture training, you have to go to MCPHS. My client applied for federal student loans under the FAFSA program in January of 2015. She was approved for loans to study full-time, and
Actually, Attorney Perilous, we're familiar with the background of the case. Can I want to let's move into what's contested here.
Sure.
And let me ask you about starting. So, after this, you paint a picture of it going pretty sour and your client being given bad advice and such that she's going to lose her forgiveness for the other loans.
Right, she was defaulted on her student loans.
On June 2nd, when she withdraws, she says, on June 2nd, 2016, she withdraws for theft of her student loan. Why is she not on notice, at least on June 2nd, 2016, about all of your tort claims?
For one thing, because the student loans weren't stolen. There's no theft allegation in my complaint.
I mean, so they're not, but there's something, she knows something is amiss. And in fact, she got those.
She knows something is amiss because she was forced to drop out. It took me years.
But she knows it, but theft, she says. I mean, she has something to do with money. And the part that you discovered about the spreadsheets is that she was sort of on notice of that too, because she got those checks. She got checks in October and January and February and March that add up to somewhere around the $10,800, right? I mean, she sees this money dribbling into her.
Right, but she has no idea what's actually going on. She has no idea what's going on behind her back. I would like to draw your attention to that spreadsheet where I lay out Record Appendix 3, Section 83. I would like to draw your attention to that spreadsheet. If you take a look at it...
Is this a spreadsheet that you...
It is a spreadsheet that I produced.
Okay.
So this is what I did. In 2018, I still had no idea why she had been forced to drop out. I looked at the FAFSA records. The FAFSA records showed that there were funds available for her summer term. And suddenly those funds disappeared. And at the time, I thought the school outright stole those funds. I believed that it was a theft. And I wrote a first demand letter claiming that the school stole those funds. But I was wrong. What they did, if you take a look at that spreadsheet, and you go to October. So the school, Will Kribbe at the school produced an accounting of her. She demanded an accounting to try and figure out what had actually gone on. If you take a look at that accounting, it's ludicrous, it's incoherent. It's double entry items to make it deliberately confusing. But I have experience in spreadsheets. So I took their accounting and I put them into an Excel spreadsheet. The first thing that hit me about the accounting was that it's a basic principle of accounting. When you write up a ledger, you have the debits and the credits. If you want to,
but I'm sorry, but on the discovery rule and the statute of limitations, you created this spreadsheet using the FAFSA documentation,
I combined
which was available to your client before June 2nd of 2016, right?
Certainly, but she doesn't have my spreadsheet skills. If you take a look at that.
But so are you saying that the discovery rule is it's not discovered until you find somebody with spreadsheet skills?
Yes, because because they were breaching a fiduciary duty, and then under the fiduciary law, you have to have actual knowledge of the breach, not imputed knowledge. And I didn't have actual knowledge until I put together that spreadsheet. I took the MCPH spreadsheet, and then I took the FAFSA spreadsheet, which had the dates when the funds were transferred. And I realized that the school had borrowed $10,857 interest-free for 3 months while she was paying interest on it. It's an unfair and deceptive business practice. It's a breach of contract. And certainly when they're administering funds, they're a fiduciary, like a bank. It's a breach of a fiduciary duty.
You have cases that you cite in your brief to support the fiduciary duty definition that you provide, the dictionary definition that you provide, and make it applicable here?
Yeah, I do. One moment. Actually, no, I got a relatively concise description of fiduciary duty from one of your cases. Peterson versus Richard, 2008, Mass Appellate Court. It's an unpublished Lexis decision 378. And it reads as follows: a fiduciary duty exists when one reposes faith, confidence, and trust in another's judgment and advice. And then I'll skip the cites. The fiduciary's duty is to act for the benefit of the other party to the relationship as to matters within the scope of the relation. Again, I'll omit the cites. In determining whether a fiduciary relationship exists, as a matter of fact, several factors require consideration. One is whether the circumstances surrounding the relationship would lead a reasonable person to believe that he or she could confide in or rely on the other for a particular purpose. Now, as far as student loans go, she was totally reliant on their advice. A second concern, the relative degree of skills or expertise in the relative degree of skill or expertise the alleged beneficiary and fiduciary possess with respect to the matters the fiduciary relationship allegedly covers. My client has no experience with financial matters. She had a degree of fine arts. So she relied on their knowledge to make the decisions. And they started it out with...
Excuse me for interrupting you, but as of the date that your client provided her notice of withdrawal, she was aware that there was mishandling of her funds, maybe a difference between stealing and borrowing, but she was aware that there was mishandling of the funds, correct?
No, she only thought they were stolen. I mean, yeah, I guess you could call that mishandling, but it's not... She was aware that there was something wrong going on, but at the time, we still had no idea why she was forced to drop out. I didn't figure that out till 2020. The school claims that she missed a quarter credit. The school set her up to begin with. They got her studying exactly half. First, it began with a lie. They told her she only had funds to study half time. I didn't figure that out till well after, until 2018. They set her up with exactly 6 credits. So if any of her classes got canceled, it would go below half-time and she'd be defaulted on her loans.
Was that fact concealed from your client, that some of the classes were pass-fail and only one of them was graded?
No, but what was concealed from my client is that in the spring of 2016, she had 2 cadaver labs, 2 quarter credit classes, which she actually had none of the prerequisites for. And again, I didn't figure that out till much later. But anyway, one of the cadaver labs was rescheduled. They never informed her that it was rescheduled. Her online calendar was blank. She missed the class. Actually, she went to the school in a snowstorm to attend the class. The class wasn't there. It was rescheduled, and they never told her when it was rescheduled. And in Will Kribbe's statement to Leah Barrows, which is at the very end of Appendix H, Will Kribbe told her that she had missed the class and that she'd missed 1 quarter credit class, bringing her credits down to 5.75 credits. And that's why she was reported to her undergraduate lender. But that was a lie. They actually canceled 2 quarter credit classes. One of them was the class that she missed, and the other one was a quarter credit class which they simply canceled and chose not to reschedule. So nothing she could have done would have kept her from being defaulted on her student loans. And I didn't figure this out till years later. I didn't figure this out till I did that spreadsheet in 2018. And then I didn't figure it out till 2020. I went back, because I was underemployed during the pandemic, I went back through the file. I was going to close the file, and I went through, and I found I found a record showing that she had 2 classes. I found 2 emails discussing the 2 classes. One said, one class has been rescheduled and you missed it, and the other one said, one class has been canceled and it's not being rescheduled. So for the first time, well after 2018, I finally understood why she had been forced to drop out, and neither of us understood it before then.
Can I ask you, I've got two more questions. You mentioned, you read from the Peterson case before. It's not the Peterson you cite in your brief. It's an unpublished decision of this court. Can you give me that cite again?
Sure. Peterson versus Richard, 2008, Mass Appellate Court, and it's unpublished, Lexis 378.
Lexis what?
378.
378?
Yes.
Okay. And the other question that you say in your brief that this is kind of troubling, that the defendants admitted destroying emails, test results, financial documents, and the contract. You say the defendants admitted that, but you give no cite in your brief there of when or how. Is that in the record? Is that admission in the record somewhere?
It is, and I put it in the record in their discovery responses.
Could you tell me where it is? Is it it's in their discovery response? It is in their discovery responses that the documents have been destroyed, and the discovery responses are included in the record. And the sense that you say they were destroyed 2 days after she withdrew?
I don't know when they were destroyed. Okay, so the student manual says you have 30 days to recover your emails, and I have a page from the manual discussing that in the record. She withdrew on the 2nd. She and I furiously copied down emails, but she was cut off 2 days later. That's a contract that she has 60 days to recover her emails. They cut her off 2 days later. I don't know when they destroyed all the other records, but under the CMR, let's see, it is...
It's in your brief, right?
Right.
Yeah,
under the CMR, they're required to keep most of those records for 7 years, and they're supposed to keep her financial documents for, I think it's 61 years.
So when they were cut off after 2 days, did you call the school and say, hey, we need access to the emails, or?
Leah called the school. They told her, you're done. They basically refused to talk to her. But I was there. I witnessed it. I was there when they cut her off 2 days later. That's a breach of contract with a 6-year statute of limitations. And the spoliation, the destruction of evidence, I found out about that during the course of this case. That opens the statute of limitations right into the period when we were litigating. I'd like to be heard a bit on the conduct of opposing counsel. I submitted an opposition to his summary judgment motion with exhibits, and I sent him 2 printed paper copies, and I said, use my paper copy. He printed his own copies. He took 10 of my documents and enlarged them to make them illegible. So I had to go down to the courthouse to make sure this was actually in the record to prove it, and sure enough, I had to resubmit all those documents to make sure they would actually get into the record.
Did you file an affidavit with your opposition?
I did, and my affidavit discusses this, and I produced those
An
documents
affidavit
for
of whom?
Excuse me?
An affidavit of your client?
Yes, the affidavit. There are affidavits from me and from my client covering all of these issues. I also would like to. I would also like to discuss a bit my reply brief. My reply brief.
Actually, I'm sorry, Attorney Perales. Your 15 minutes is over and going up, and we'll take a look at everything. Thank you for your argument.
Thank you, Your Honor.
Good morning. May it please the court. My name is Guy Tully. I'm counsel for the defendants in this case, having taken over for Paul Kelly, who was trial counsel. Despite the sound and fury and the unwarranted personal attacks on Attorney Paul Kelly, the court personnel, and Judge Boudreau, the legal framework entitling defendants to summary judgment in this case is actually quite straightforward. The court properly recognized and concluded that the underlying tort claims in this action, counts 1, 2, 4 through 8, are clearly barred by the applicable 3-year statute of limitations. As to those claims, Judge Boudreau properly concluded that the claims accrued by no later than the June 2, 2016 date, the date upon which the plaintiff in writing filled out a form saying that she was withdrawing due to alleged theft of her loan funds. Excuse me. All of her tort claims relate to, in some way, her belief that her student loan funds were stolen or misappropriated, or that she was otherwise misled into taking out loans or taking courses during her enrollment that she shouldn't have had to take.
How do you respond to the argument that your client had a fiduciary duty to her, and therefore it's not a constructive knowledge but an actual knowledge inquiry?
Your Honor, Judge Boudreau properly recognized that it's very well settled in the Commonwealth that there is no fiduciary relationship between the student and the educational institution. Plaintiff is not, until today, I'm not aware of any case that has been cited by the plaintiff that establishes otherwise. And the reason that's relevant is that's the only way around the 3-year statute of limitations that really the plaintiff could have. There's been no concealment here. I mean, he asks, or somebody asks why she withdrew from school. Well, we know why. She said so on, in her memo of withdrawal on June 2nd. She didn't file her complaint in this action until I believe it was May 15th, 2020, almost 4 years after she withdrew, and gave the reasons why she withdrew. And for that reason, all of her tort claims are barred by the 3-year statute of limitations.
Is the handling of student funds, including loan funds, part of the core function of the school?
Of course it is, yes. And that's why I believe it's count 10 also fails. That's the 93A claim. That's not, there's well-established precedent there too. I think it's the Thurston case that held that the handling of student loan funds does not constitute or is not commerce within the meaning of Chapter 93A. And as far as the breach of contract claim, I'll be brief. As Judge Bedrome noted, there really is no evidence in the record of a breach of a contract, even if you assume for the sake of argument that one existed between Ms. Barrows and the university. She took the classes. She did not pass her anatomy and physiology class. She was permitted to retake that final. She did so. She failed a second time. She didn't appeal the grade that she received pursuant to any internal university processes that were available to her if she felt that she was given an improper grade. In fact, she admitted in her deposition that she really was, not challenging the failing grade that she received, that she was prepared to accept it. And so for that reason, there really is no specific provision of the student handbook that they've established.
Although, a lot of there does seem to be a dispute about the kind of advice that she was given when she was signing up and whether that set her up to fail. I mean, doesn't she have some sort of right to get, be told by the school what courses to take or how to, not sign her up for things she's not ready for?
Yeah. Again, Your Honor, I mean, there was not a fiduciary relationship there that would hold anyone at the university to a heightened standard, but clearly...
Contractual, just a contractual.
Contractually, they engaged with her. They had conversations with her. There was nothing improper about the courses that she enrolled in. She passed them all except for the anatomy and physiology class. And to say that the university was the only institution that was responsible for providing her advice about her student loans is simply not true. I mean, she had the lenders who she could go to if she had questions. Her problem started because she defaulted on her undergraduate student loans, not a loan that was administered through MCPHS University.
But wasn't that because she wasn't a full-time student, because she'd failed one of the courses?
Because she had failed a class, that's right. She didn't have a requisite GPA. She was on academic probation at that point. But that's, again, that's well within the university's, core mission, those interactions with her and with her lenders, if any.
Did the schools destroy some of her documents, emails, test results, cut her off after 2 days?
Your Honor, I wasn't involved in that level of the case, back then, but my understanding from the record is that there were certain documents that were deleted in the normal course or otherwise gotten rid of in the normal course. That was the subject of Mr. Peralez's, I believe, spoliation motion that was denied by the trial court and by this court. And he didn't file his actual action until 2020. His demand letter came in 2018, and I'm not aware that there's any evidence of any document destruction or spoliation after receiving that.
Is it your position that the letter that said I'm withdrawing because I alleged theft was insufficient to put the school on notice of possible litigation to follow?
It is. That is my position, yes.
Do you have a case that would support that in some way that's factually comparable to this one?
I would. Nothing is coming to mind. I would also just further note that in terms of the general analysis of the statute of limitations and the applicability or inapplicability of any sort of equitable tolling doctrine in this case, I would just direct the court's attention to a decision I believe was issued last Wednesday, Marks versus Ross, University of Veterinary Sciences. I have copies if the court would like one. Otherwise, it was just published I believe it was last Wednesday, upholding those principles.
No, yeah, we're familiar with it.
Okay.
Yes.
And for the balance of the arguments, I'm happy to rest on our papers.
I know there's a statute of limitations issue, but it does, the spreadsheet or just the checks, it does look like the school was holding back about $10,000 of her student loan, and which was dispersed to her. It was held between October to January, February, March. What is the reason for that?
It was just processing in the normal course, and I think there was uncertainty about her current efforts to get additional loan funds. Again, I would have to defer to what's in the record on that, but I just don't see that as any breach of contract, and to the extent that he's alleging it was a violation of a fiduciary duty or misrepresentation or anything like that, it's clear that both Attorney Perales and his client were well aware, or at least believed that there was something wrong with the loan funds at that point in time, and to not file their claim within 3 years rests with them.
All right. You see no more questions? If you have nothing to add?
I do not at this
Okay.
point. Thank you.
Well, then the case is submitted. Thank you both for your arguments. Our fifth case this morning still is Bailey versus MDM Realty Trust, 25P421. No, let's wait for Attorney Perales. No, let's give him a second here. Okay.
Please, the court. Good morning. I'm Attorney Michael Maskis. I represent the appellants Teresa Bailey and Ronald Bailey. And this is a case where involves a slip and fall accident that occurred at my client's as she was going to work at her employment at 30 Floral Street in Worcester, a company called Little Beginnings Daycare. The property was owned by MDM Realty Trust, which was the relationship between them and our employers, that the trustee, Edward Muntz, was the father of my client's employer, Melissa Muntz Cole. But in this case, the crux of the case is the fact that the defendants are defending a negligent maintenance snow and ice case by claiming there was an oral modification of the contract, a written lease between MDM Realty and MDM Educational Services, which was the company that ran my client's employer.
Okay, can we go ahead? No, can we start that in putting aside the contract for a second? In the normal course, when you're suing. When somebody like Little Beginnings here leases the premises, and it seems like they lease the entire premises, and would they normally be, the tenant as opposed to the landlord, be responsible for maintenance without a contract? Maybe, if it wasn't specified in the lease.
Well, there's a common law duty for an owner.
Does that transfer over to the tenant if they're controlling the property?
Well, I suggest there's a dual duty. It's not exclusive, and that they're joint tortfeasors in some way, but in this case, my client can't sue her employer as she received workers' compensation.
Is it correct that I'm sorry, did you finish your answer to Justice Massing's question? Am I understanding correctly that your theory of the case is that there's some kind of hide the ball being played between the landlord and the tenant about who was responsible for maintenance here legally?
That's the defense they raised, Your Honor.
All of the evidence that, as it exists, is that there was an oral agreement that transferred, that there was an agreement and leaving the legalities aside for a minute, between the landlord and the tenant, under which the tenant agreed, notwithstanding the provisions of the lease, that the tenant would assume responsibility. That's what the evidence is at the moment, correct?
We disagree with that, Judge. We say that that is a self-serving statement by the owner. There's no other evidence of it. The only evidence of any agreement as to who's responsible to maintain that parking lot is the lease.
So my question, I guess, is this. Do you have a case that supports the argument that summary judgment is defeated by the fact that the jury might disbelieve the undisputed, I'm going to call it undisputed evidence?
Well, Your Honor, I would say, again, I take issue with the undisputed.
So let's say if all the evidence that exists is that this contract, oral contract took place, putting aside issues of credibility, the only route that you have to avoid summary judgment, it seems to me, unless I'm missing something in the record, is the jury's disbelief that such an oral contract existed. Is that true?
No.
No evidence that the contract didn't take place.
If the jury believes that the lease is the actual meeting of the minds of the two parties.
But that's a question of law, right? I mean, whether the lease prevails or the oral agreement prevails, is that a question of fact or a question of law?
Well, the cases we cited, when they raise the issue that there's been a modification, that modification becomes a question of fact.
But those cases all, if I'm not mistaken, deal with situations in which the putative contracting parties are disagreeing about whether there was an oral contract and what the significance of it was. Is that true?
Are you mentioning the Schenkel case that the trial judge relied on?
Putting that aside, are there other cases that speak to that, have the same factual situation you do, where your client is just trying to poke holes in the existence of an agreement the other side claims is controlling?
Well, no, Judge, I don't think there's any way that you can disprove a verbal agreement other than by the objective analysis on the outside by a finder of fact. And again, the cases talk about what's their conduct, and the defendants suggest their conduct supports their argument. We suggest the conduct absolutely erases this agreement because, as we've argued, there are two leases. There are two lease terms. And the 2006 is the first signed lease between the father and the daughter. And I emphasize, these two parties run a number of different businesses before this out of this same address. And there's a Little Beginnings Inc. that's in the record where Mr. Muntz is the president and Ms. Cole is the secretary. And they work under this same lease. And the lease in 2006, their best evidence is after 4 years they decided the verbal agreement, the daughters will, Ms. Cole will conduct all the snow and ice removal and maintenance. But when they have the chance to memorialize that in any way, there's no email, there's no written document, when they have a chance to memorialize it in the 2018 lease that they resubmit, modify in some ways, and sign, the obligation still remains with the landowner. And so whether or not this alleged oral agreement exists, again, we're suggesting the jury should make this call.
So let me just, tell me if I got the history right here. The first motion, at the motion for summary judgment, the motion judge actually agreed with that.
Correct.
She said there's a material dispute between their depositions, I suppose, or their whatever answers to interrogatories, and the written lease, where they contradict each other. And then on motion for reconsideration, lo and behold, they have invoices from the snow removal to the two Little Beginnings, and then the judge says, oh well, that to me confirms the course of conduct.
Well, the judge isn't clear on what triggered her decision, but the facts are the facts. There's no other change in the evidence except for those invoices. And again, those invoices are just invoices. They're not a snow and ice removal contract. And in commercial conduct, a snow and ice commercial contract, they're negotiated over as to who notifies whom when the snow plows are supposed to come. You know, how many inches
So, so in discovery, you got none of that from the defendant. And I take it, did you do any, Rule 45 subpoenas to Little Beginnings?
We subpoenaed we took the deposition of Ms. Cole. And at that time, she said that she had a snowplow contractor. She couldn't name the person. She claimed she might have some documents, but she didn't produce them.
Are the documents all that important where the testimony Ms. Cole gave was that she had paid for the, I mean, I understand that they corroborate. What I'm asking, is it merely corroborative of the testimony that Ms. Cole gave about the fact that she had, or Little Beginnings had assumed responsibility and had followed through with that historically as far as maintenance of the property goes?
It's just her testimony is the only evidence of that, Your Honor.
Right, but there was that evidence, and no one provided evidence that your client didn't provide evidence that someone else provided the maintenance during that period.
The snowplow contractor was never identified during discovery, and we never had the opportunity to depose him. But the other aspect of the case, we're suggesting it's a very simple, this should not be a momentous decision, because I think the cure is to remand it so a jury can make an objective decision as to whether these two, father and daughter, again, who had these multiple businesses together, all of a sudden decide to deal at arm's length with the contract. Why do they get the benefit of ignoring that contract? Secondly, the procedural thing that occurred in this case was we would ask the court to look at, which was when we received the motion for reconsideration, the first time we received these invoices, we immediately filed a motion to strike, because the proper procedure would have been to produce those to us and let us follow up on discovery. So that the judge never ruled on the motion to strike.
Did you make a request that you be permitted an opportunity to do some follow-up discovery before that motion was heard?
I didn't file any, no, my first and only reaction was the motion to strike. And strategically, we believe the judge would agree with us.
And you don't know one way or the other whether she did or didn't. There's no indication that the judge relied on the documents that were attached, and there's no indication that she didn't, correct?
Only, yeah, her decision is not clear on that. She focuses on that Schinkel case. And
well, the judge does rely on the party's conduct conforming with the terms of the oral modification. And the only conduct we know about is the lease agreement, which doesn't conform with their terms of the oral modification, and these invoices.
Yes, well, the lease agreement has a couple clauses.
I think that's favorable to you. I think it seems to me that the judge is swayed by those invoices.
Oh, yes, Your Honor. I believe she was, and I believe that was, again, I think the proper resolution would have been to deny the motion for reconsideration and to allow the case to continue, and then at a juncture, even at trial, where the jury could have filled in the blanks on some of these issues, but the plaintiff never had that opportunity, Your Honor. And so we are.
And I understand you're in a difficult position because the oral agreement is between, two people who are, one's on the other, I mean, they're basically on the other side of the V. Like, you can't sue Little Beginnings, but they're basically, you don't have access to those conversations at all. And but if it were to go to trial, it'd be your burden to establish that they didn't have an oral agreement and that the lease agreement was the final agreement. So on summary judgment, it's their burden to say you have no plausible way of disproving it. And so,
unless the jury believes that they're not being truthful about it, Your Honor, and that You know, at one point in the timeline, after 2010, Mr. Muntz is still on the board of Little Beginnings, Inc., and he's claiming he's modifying a lease to himself. You know, he's the president of that company at the time. So it's convoluted, it's confusing because of this very close relationship between the father and the daughter.
What's the evidence the jury would likely hear about a motivation for either one of the two, or for either the landlord or the tenant to lie about whose responsibility it was to maintain the property?
The lease, if I'm hearing you right, Judge, the lease, paragraph 9, I believe, states that the landlord has the duty of maintenance. It's just a broad maintenance duty.
Right. But is there some way that the jury was going to have a motivation to believe that that what was being represented by the defendant and by the landlord was untrue?
Well, yes, Judge, there's a public policy aspect to that where someone who owns property is sued and he says, well, just ignore that lease I signed. I really meant to transfer these duties to someone else.
Okay.
I think we understand your argument. If you're
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. I'm John Lang, representing MDM Realty Trust. The invoices submitted for the motion for reconsideration were just additional support for our position, but they were entirely redundant and superfluous.
But weren't you required to supplement your discovery responses with those once you had them? Is that trial by ambush something that we encourage?
Well, Your Honor, I mean, my client didn't have them, and then I just got them. I just called up Melissa Cole, and said, "Hey, could you send me those invoices?"
Right.
And
Did they ask in her deposition about them and she didn't know about them?
No. Here's the thing, Your Honor. So first, MDM answers interrogatories in March of 23, and answers 6 through 10. This is why this is all redundant testimony, these invoices. It's a red herring because it was entirely redundant. MDM answers in answers 6 through 10 that Little Beginnings had they were asked about the snow removal, sanding and salting at the time of the accident, and he said, well, Little Beginnings had that responsibility. He repeated that in several answers. Then Melissa Cole's deposition is taken in August 23, and there's no request for documents there at all, okay? So at the end of plaintiff counsel's questioning, I elicited the testimony, as you'll see in the transcript, I elicited that testimony about the oral agreement. And she went into great detail about the whole history between her and her father. He wasn't getting it done. He wasn't taking care of things. And so she decided that she or the school would take it over in 2010. And she went into great detail about that, and that has continued to the present time. And I asked her about the lease and showed her the lease. She said that was the first time she saw that provision was still in the lease. She said, my father probably got some form online, and we just signed it. The only real purpose to signing that lease because he wanted to raise the rent after several years, and we probably didn't read it. But she goes into great detail about why they did it, and then that it has continued to the present time. So the court had the MDM answers for the motion for summary judgment. They had the Melissa Cole testimony. And thirdly, they had the Melissa Cole affidavit, which kind of condensed what she had already said in her deposition, and specifically...
But with all that, the judge denied summary judgment.
Right, and I'm going to get to that, Your Honor, okay? And so she has all of that, and she says that and I asked her in a deposition, so after you after the lease, did you continue to maintain the property and do all snow removal? Yes. Now, the judge rules, and this was probably an inadequate argument by me at the summary judgment hearing. She says there's an issue of material fact for the jury to consider as to who is responsible for snow and ice removal, since the lease between the parties did not reflect the earlier change, given the language of the lease. Therefore, there's a material fact. So, as I said in my motion for consideration, the court seems to be taking the position that that the two parties were required to undergo the formality of repeating their oral modification after that lease was signed. And so that's why I filed my motion for consideration, highlighting the Schinkel decision and clarifying for the judge what I probably should have done better at the initial hearing, and that is that the subsequent conduct conforming with the prior oral modification is evidence of the continued oral modification of the contract. She already had all of that evidence, but I think the court misapprehended that it was not required to do another oral modification under the Schinkel and Flynn decisions, that if there's an oral modification prior to a written agreement, and then the parties after the written agreement continue to conform to that oral modification, if the conduct of the party shows that they continue to conform with it, then the oral modification is valid in the enforceable agreement. So I don't think Judge Duncan at all, she certainly doesn't reference anything, and all that she's saying in her motion, her ruling on the motion for reconsideration, she cites the Schinkel ruling and says, because of the moral or modification of the written lease between MDM and Little Beginnings, because of the continued conduct, that is sufficient to ratify the prior oral modification. She doesn't go into any evidence, and again, the invoices were just the fourth, if you want, of the evidence that was already before the court. She had a strong affidavit. She had strong deposition testimony. None of it disputed. She had answers to interrogatories from MDM. None of it disputed. There's no evidence disputing this oral modification. There's no evidence disputing that from 2010 through the present time, and certainly through 2011, at the time of the accident, that was the course of conduct in conformance with the oral modification, which they made in 2010. And by the way, I wanted to point out that I made an error. I realized on page 7, where 2018 is referenced at the end of the paragraph on that page, it should be 2010. So that's all the court was doing, is applying the Schinkel ruling to the undisputed evidence which she already had. And I think do not think there's any indication that this fourth piece of evidence submitted to her had made anything different. She already had all of the evidence she needed before her. What was just, I think, I just needed to clarify and highlight the Schinkel decision for her better than I apparently did at my oral argument. That language, or most of that language, was cited in my summary judgment memorandum. However, again, I don't think I pressed that point enough to the judge or clarified it enough to her, and that's why she got the decision, understood, read it, and applied that decision to the facts. Now, can I again on the invoices? there was never, MDM didn't have them. He took Melissa's closed deposition, didn't ask for any documents, didn't even discuss any of these issues at her deposition. I brought out the testimony. Could have followed up, didn't have a document request for the deposition, could have followed up with a subpoena or a call like I did. I was not trying to, I was just trying to provide a little further support. It was not trying to be underhanded or anything. We were beyond discovery at that point. I got them, you know, as I filed the motion for reconsideration. It was sort of simultaneous at that time, Your Honor. So I wasn't trying to, you know, pull one over. There was no aha moment. This was completely redundant and superfluous evidence. As Your Honors know, in considering summary judgment, the court does not assess credibility of witnesses, and any inference to be considered must be based on probabilities and not possibilities or speculation and conjecture. So there is no basis that the plaintiff has not presented any basis other than father and daughter, and the father sitting on the board to suggest that there's anything afoul here at all. It was simply an agreement between a father and a daughter that Dad's not getting it done. We're gonna take this going forward. And he agreed, and that's all we have.
When did you actually get the
Your Honor.
invoices? What was the date that you received them?
I'm sorry, Your Honor.
When did you receive the invoices?
Just like simultaneously with filing my motion for reconsideration. Just like that week, I guess, you know, when I was preparing the motion for reconsideration, is when I just requested the invoices. I don't think they were necessary. I don't think there was.
Because in the response to the request for production of documents, there was an affirmative statement that you didn't, that your client did not have them.
I didn't.
And there's an obligation to look to agents and et cetera, correct? I'm just curious as to the timing. So that was almost a year earlier that you affirmatively said that you did not have
That's
them.
correct. That's correct, Your Honor. I didn't have them. At that point, he had been, you know, not doing the snow removal for, I think, 13 years. So he didn't have any of these documents. I just said that he did not have any. And I didn't know what existed for invoices or anything. I just, when I was filing my motion for reconsideration, I just called and said, "Do you have any invoices that I could you know, that you could send to me?" That's all. And after those answers to interrogatories were served, no deposition of MDM. Now, there's never been a deposition of the defendant in this case at all. And so the two parties to the contract said in his answers to the answers to interrogatories that Little Beginnings took care of the snow removal. Melissa Cole from Little Beginnings comes in and testifies in detail, based on my questioning, about this oral agreement, and then signs an affidavit. So there's overwhelming evidence, and there's no evidence to the contrary, other than suggesting that there's some untruthfulness here going on, Your Honor. The defendant has submitted affirmative evidence negating an element of the case, in this case, the legal issue of duty, and the plaintiff has failed to submit any evidence, any facts to establish any genuine issue of material fact on that, Your Honor. All he's done, Your Honor, has made assertions. There's no evidence to actually establish any genuine issue of material fact.
Just on the legal issue here, your response in terms of the governing law, I take it your response is the parole evidence rule is really completely irrelevant here. We're not talking about using evidence to modify the terms. We're talking about a subsequent agreement. And that's an entirely different line of cases.
That's correct, Your Honor. Yes. Yes.
And
This is a subsequent oral modification, Your Honor. Parole evidence has to do with prior oral agreements, but that's what the Schinkel case was about, saying that if there was a subsequent oral modification, and then the conduct of the parties can establish the ongoing oral modification of the contract, Your Honor.
And is there any reason why, if there hadn't been any discussion in the lease about who's responsible for maintenance, it would fall on the tenant?
It does. It does. The tenant owned the whole property, Your Honor. Yeah. I mean, the tenant leased the whole property.
Leased the whole property. There's no other businesses on the property.
There's no other businesses at all. He's put in some evidence of some old, Secretary of State documents that business.
What about the thing about Little Beginnings being involuntarily, the Secretary of State dissolved it in 2012? Did I read the record right?
I think the Secretary of States do that if you don't comply with filing annual reports, I think, Your Honor. That's my understanding. Haven't looked at that website a lot to get corporate documents, that if you don't comply with, I think, your annual reports, they will dissolve the corporation.
But Little Beginnings did pay workers' comp insurance and is on the hook on that.
Say again,
Little Beginnings had workers' compensation insurance and isn't contesting liability under that. As far as you wouldn't know.
No, they paid all of the workers' comp, and this is outside the record, but I'll say it.
Well, no, don't.
All right, okay. Which insurance? About insurance. I'll leave that outside.
Yeah.
Right.
Okay.
Yeah, I believe that the motion of reconsideration ruling is clear that the judge was simply I highlighted for her, underscored for her.
No, I actually said that when the red light goes on, it starts to count up. So it's confusing to people, but I think we understand that.
Okay.
So thank you both for your arguments. Really interesting case. So
thank you, Ron.
And last but not least, I'm sorry to council that you're back to the bad old days where the DCF case is always on last. And so last for this morning is, actually now this afternoon, Department of Children and Families versus Mother, 25P507. I'll remind you that this case is impounded, and so do not refer to the mother or the children by name.
Morning.
The long morning, huh?
Oh, there we go. May it please the court. My name is Jeremy Thierman, and I represent Mother Appellant in this case. I do want to let the court know this is an unusual situation that I'm in, that I'm arguing a brief that I didn't author. I came in 6 or 7 weeks ago on this case for reasons that I don't have any privy to. But I just did want your honors to know that.
So you're obviously not responsible for what predecessor counsel put in the brief. For example, counsel cites section 29 and 29C and an unpublished decision, Darrell, for the proposition that the judge is required to make detailed findings about the fitness of the maternal grandmother. The law and Darrell don't say that, do they?
I did not find support for that in that case or in those statutes, and I dug as deep as I could to find some support for that. I think this case really falls under the rubric of reasonable efforts, where there's a number of things in this case that I want to touch on that really go to reasonable efforts. I'm going to touch on the, one is the fact that termination of parental rights is a last resort. The other issue I'm going to touch on is DCF's failure to engage with grandmother and follow their own regulations and policies with respect to how they dealt with her. And then finally, I would argue to your honors that the record that we have before us is inadequate to terminate parental rights. And I know this seems like it goes off into a few different directions, but I really think that this all falls under reasonable efforts. And that's really based on the factual support for each of these issues. So terminating parental rights is a last resort.
Had the mother's parental rights been terminated with a sibling of the child?
There was, so the short answer is no.
Okay.
There was a previous case, there was a termination. That case was still pending appeal at the time of the trial. Yeah, I believe that it was still pending as of the time of trial. And I'm sure my sister will correct me if I'm incorrect on that, but that was my reading of the record, that it was still pending then.
Meaning pending on appeal?
Pending on appeal, yes, yes. And I apologize, I didn't explore the issue of whether or not that satisfies a requirement for reasonable efforts in terms of can the court rely on that determination to find that reasonable efforts is not necessary. But it seems that the court did hold DCF to a reasonable effort standard because they made findings about it in their rulings. With respect to terminating the parental rights being a last resort, this situation is one where the proposed guardian, the grandmother of this child, is in a guardianship with another child of mother. And this was her natural support system. And DCF really cut off like the natural process that we have in relying on our extended families in these types of situations, as she did earlier with her son. Her son has been in a guardianship since 2015. There had been DCF involvement in that situation, but the guardianship itself is out of the probate court. And so that was done between the parties. And in terms of how DCF interacted with the grandmother as a proposed resource is very troubling in this case. And I say that based on the fact that the trial testimony seemed to be that when grandmother stepped forward and said, I want to be a resource, DCF told her, you wouldn't be eligible. In fact, the transcript, the testimony, in fact, says you wouldn't be eligible to apply. And I would suggest that that's not what should be done in these cases. If she wants to be a resource, there should be an application, there should be a process.
So I'm sorry, what do you mean it's not what should be done? So is it accurate that she was not eligible at the time that she inquired when the child was removed a few days after her birth? Was she eligible at that time based on what was happening in her own home with DCF and or her criminal record?
So, Your Honor, I would say that it's not clear because she didn't go through that process. If there's something that makes her ineligible, it would be, I don't want to say discovered, but it would be fleshed out in that application process. In this situation, there was an open matter in the grandmother's home, but there are waivers that can be applied by DCF. So it's not a cut and dry situation where if you have this, absolutely no way, it can't be waived. DCF does waive certain requirements for resources, and I believe that they do have some discretion in doing that. I think what we're seeing here is a situation where grandmother was discouraged from applying. So there was no paper trail of her stepping forward. There was no formal decision, which anticipates, I think, something my sisters would argue in terms of notice to the department. Because there was no application early on in the case, there was no determination from which the grandmother could appeal administratively or raise an issue.
So are you saying that she was discouraged, or that she was told, listen, you've got your hands full, and with what's going on in the home now with the older child, it's unlikely, or it's not, it's improbable,
The words in the transcript are not eligible to apply. And I think that's very clear. Like, they were telling her, I mean, they may have said anything to her, but when it comes down to the record's very clear. They told her, do not apply. And that, in and of itself, I think, creates a situation where DCF is, I mean, it's improper for them to not take an application from a resource, especially where the law requires that when DCF is looking for foster placement, that they consider placements with kin. And there's also a sibling in this home. I know the evidence, maybe one way or the other in terms of, is that a good situation, but placement with siblings is also preferred.
Do you have a case that speaks to what that obligation is of the department? Whether it is, or perhaps something within the rules and regulations that, whether there's, who has the burden to, provide her with an application or not, or that discusses those facts? Because I'm also concerned about, personal responsibility here. I mean, maybe she didn't, I know what her testimony was, but, she did have her hands full at that point. And the second part of that is, when's the point when, the responsibility is on the grandmother to come forward and say, things have been ameliorated in my home, now I want to apply, rather than DCF, where's the burden?
So I don't have an authority to point to it spells that out clearly. What I would point to, though, is in this case, the testimony of the adoption social worker, and it's a very concise, like, page or so in the transcript. The grandmother had come forward at really 3 separate occasions: on birth, on discharge from the hospital, and then when family find letters went out. And the testimony of the adoption worker is that she discussed the situation with her supervisor, and a decision was made to provide an application to the grandmother. So that tells me, at least as a matter of practice, DCF is performing some sort of gatekeeping function with respect to those applications. And I don't think it's an unreasonable inference to look at this situation as one where grandmother was discouraged from applying, and at some point, it was realized, well, wait a second, she hasn't even had an application, so we can't, put on the record why she was denied. And the testimony from the ongoing worker was that application went out, she said, several months after she came on the case. She came on the case in May of 2023. Does several months mean 3? Does it mean 7, 8, 9? I don't know. That testimony was in June of 2024. So at some point in that year, an application went out to her, and the adoption worker had gotten that application back. She testifies a week or so ago. So that application didn't come into DCF until a week or so before we're looking at a trial. There's no evidence in the record as to exactly when that application went out to grandmother. you know, so perhaps, you know, there may be some argument that grandmother sat on that application. It doesn't seem like that's the case, given that she was advocating early on to be a resource for her granddaughter. And I would suggest that that behavior, the violation of their own you know, rules and regulations when it comes to dealing with these things, really impugns whether or not the trial court can then say reasonable efforts were done here, which really is the crux of this case. The record in and of itself.
I follow you to almost to a point there, but there's no obligation to conduct reasonable efforts to reunify with a grandmother. I mean, DCF does have in their regulations that they should start with family members as resources, but I mean, and for, you know, whether how much of a reasonable effort they made to do that might be in question, but ultimately, doesn't the judge have enough information to decide between DCF's plan and the mother's plan?
So I would say no. They don't have enough information, and I'm basing that on the scant findings in the judge's decision with respect to the child. The findings with respect to the child that are substantive are probably half a page. They talk about things in generalities. They talk about she has some medical needs, but there's no diagnosis, there's no discussion of any medical interventions she needs. There's nothing of that sort. Moreover, where DCF has placed the child in a pre-adoptive home from day one and then discouraged grandmother from applying to be a resource, they have put their thumb on the scale of this case in terms of best interest from the outset. And it really falls within that concept. In terms of the considerations that the trial court has to look at when they're balancing the plans and looking at them, they have to have a balanced view. They have to have enough information. We don't know what grandmother's capacities are to care for this child. We don't know what if any special needs there were. There's also very little information about, I know there's information about bonding, but there's really no information about the child's bond with the natural mother, who went to the vast majority of visits, and there's very little issue with any of those visits cited in the record.
But we do have the testimony of the worker that even at the point right before the trial when the application was sent, that she still would not have been an appropriate placement.
So I think I understand what you're saying. If they exercised their discretion and said she wasn't an appropriate placement, regardless, why would this matter? I see my time is up. May I?
Of course. Yeah. Is that okay?
Yeah.
Sorry, I just got off track for a second. If it was going to be denied anyway, number one, they didn't give her any opportunity to improve. They didn't give her any reason as to why. The issue could have been fleshed out more. In this case, there was an open DCF case because grandmother essentially wanted services for this grandchild, received those services. That case was closed within 3 months, and her grandson was stabilized, according to DCF's brief, stabilized at that point and remains so. So I would suggest that it was pretextual. Thank you, Your Honors, and thank you for the extra time.
Thank you. We'll hear from the department first.
Good afternoon, Lynn Murphy for the Department of Children and Families. The issue before you today boils down to, did the court abuse its discretion in choosing the department's plan of adoption over mother's proposed plan with guardianship with the maternal grandmother? And the evidence overwhelmingly supports the court's determinations that the department's plan was superior. There was a plethora of evidence about the maternal grandmother. Whether or not an application was filed, the department has been involved with this family for 10 years on and off, and had 3 open cases with the maternal grandmother. There was no problem with the department not evaluating the maternal grandmother because the department was involved with providing services at the time that the CMP was going forward, which the judge noted in her findings. The child that the grandmother has guardianship of now, mother's oldest child, is significant special needs. And she, as I said, 3 cases have been opened so the department could provide her with services in helping with this child. And as you see from the findings, and there are at least 30 findings, plus 2 very clear conclusions where the judge set out her very reasonable concerns that this small toddler with her own extensive special needs would be at extreme risk if placed with the grandmother, who already struggles to take care of the older child.
So is it a fair reading of the record that the department did discourage her from trying to become a resource for this subject child?
I would not say discouraged. I don't know that the record says exactly what happened, but I know for sure that the department explained to grandmother, you have an open case, and this is a continuing problem. The social worker testified, we have problems with negligent supervision. The grandmother was missing medical appointments for the son that she's guardian of. If the grandmother had applied, there was no way that the department would have approved that application. And that did not harm grandmother's case. And she could have filed her own guardianship petition for the court to have considered. She didn't need to rely on the department. So she could have filed the guardianship petition with the CMP and said, I want you, judge, to evaluate me. But even without that, mother's counsel called grandmother to the stand, and there was testimony from the grandmother herself. So at the end of the day, the trial court had all the information it could ever need or want to evaluate the maternal grandmother as a placement.
Did the grandmother attempt to get guardianship in the probate court? Did that, when the child was born?
I'm sorry?
Did the grandmother go to the probate court and attempt to get guardianship when the child was born?
After the department filed its care and protection petition, she did.
Okay, and so then there was just no action taken on that because juvenile...
Right. But at the time that the CMP, she could have then said to the trial court judge, I'm filing my own guardianship petition. And then, as we know, the court would have considered both of those things at the same time, the merits of the department's care and protection petition along with the guardianship petition. However, as I said, the fact that grandmother did not do that was harmless because, again, counsel for mother advocated very strenuously for placement with maternal grandmother, had her testify, and brought out all of this. The evidence was overwhelming that she struggled to care for the special needs son and would be unable to adequately protect the youngest child. So the court acted absolutely within its discretion in finding the department's plan was far superior.
So just as Alan asked before, and I'm going to ask it of you, is there anything explaining the department's obligation under 110 CMR 7.101 where it seems to create a presumption of starting with a family member? The only things they cite, the predecessor counsel cited Darlene, which I don't think actually discusses it. Is there anything that discusses that obligation? Any case law, any further regulations?
Well, the regulation says the department needs to investigate family, and the department did so. If the department did not do so, and I'm sure there are cases where there could be criticism on that point, that the department could have done more. But at the end of the day, in this case, the department did a family find, did investigate the grandmother, but of course the investigation didn't need to be extensive because the department was well aware of the maternal grandmother, was engaged in providing her. Again, she had an open case, and it was open for more than 3 months. And it was not voluntary, it was an involuntary case. So again, in this particular case, the department was very aware of relatives and in fact had placed the middle child, the twin, surviving twin, with a cousin of mother. So this is a case where the department was well aware, again, a 10-year history, department not only well aware of mother and her parenting deficits that remained exactly the same for 10 years, but was very also aware of the kinship involved with this particular mother. There were no errors made below by the trial court. If there are no, excuse me, if there are no further questions, I will rest on my brief.
Seeing none?
Thank you very much.
Good morning, Your Honors. I represent the child who I'll refer to as Child O, and I'll refer to the half-brother that the grandmother has guardianship of as Child J. The court didn't abuse its discretion by selecting the foster parents who met the child's needs since she was 1 month old as her adoptive parents. Placement with the maternal grandmother would endanger the child. The judge on page 31 of her findings, paragraph 39, says the permanency plan proposed by the department has sufficient content and substance, establishes a superior plan for the child, and is in the child's best interests. Child O has bonded and is thriving in the care of the pre-adoptive family. They ensure her significant medical needs are met and provide a loving and stable home for a child. Maternal grandmother is not a suitable placement for Child O, as she cannot control Child J's volatile behavior. While she reports his behavior as abated, he is diagnosed with anxiety, PTSD, and bipolar disorder, and has multiple services in place which require maternal grandmother's attention. Maternal grandmother has minimized Child J's violent episodes, referring to them as mere tantrums. Additionally, maternal grandmother has failed in the past to keep mother from having spontaneous, unsupervised visits with Child J. There is no indication she is willing or able to limit such unsupervised contact if Child O were in her care. Such unsupervised contact with Child J likely poses a significant risk to the toddler. Moreover, this court has no confidence that maternal grandmother could successfully maintain appropriate boundaries between mother and Child O. Mother's behavior is difficult to manage even in the controlled environment in a courtroom. It's highly unlikely that maternal grandmother could control mother's irascible and volatile behavior in the home. All the evidence supports what the judge said. There's no merit to mother's argument that Section 26 mandates detailed findings regarding that no relative is available. According to adoption of DORA, where there are competing plans, the judge must assess the alternative, and if both pass muster, choose which plan is in the child's best interest. Here, the grandmother doesn't pass muster. My client would be at a lot of risk from the mother and the half-brother at the grandmother's home. It doesn't pass muster. Contrary to the mother's arguments, the reasonable efforts doesn't apply at all to relatives. And they cite adoption of Darlene, which doesn't have anything at all to do with reasonable efforts for relatives. Adoption of Jacob makes clear that in deciding for the department's plan of recruitment, in that case, the grandparents actually had custody of the grandchild. And instead of leaving the child with the grandparents, they proposed a plan of, the department had a plan of recruitment for the child, so that even in a situation where the child had been living with the grandparents and the plan was recruitment, there was no abuse of discretion in the department's plan. And that case, adoption of Jacob, upheld the department's plan of recruitment over staying with the grandparents.
I hear you saying that there's no requirement for reasonable efforts, but do you think there's any requirement of any action whatsoever on the part of the department with respect to locating and vetting a kin?
The regulation says it could start looking at relatives. They should be looked at, and clearly the department does that. In the prior termination case against the mother, the surviving twin was placed with a cousin. They certainly have to look and send out letters and ask, but that doesn't affect the vetting process. They don't have to choose a relative if there's no one that's appropriate.
I'm not saying choose. I'm asking, I guess, more, do they have to provide them any services? Do they have to get them an application? Do they have to help them fill out an application? Do they have,
There's nothing in the regulations that I'm aware of that say they have to. They have to give them notice that the child's out there and probably tell them how to get in contact with the department. But beyond that, there's no reasonable efforts that have to be made, as far as I'm aware.
I'm just looking at the regulation, and maybe you can help me. It says the department shall consider, consistent with the best interest of the child, the following placement resources in the following order: 1, kinship family; 2, placement with a child-specific family. What's a child-specific family?
It could be a foster home that they've been in.
Well, next is foster home where the child was previously placed, and the next one is foster home. So there's only
Okay, well, sometimes there's maybe a relationship with a neighbor or some other person who's, in one of my cases, it was a friend of the mother's from work. I guess that, okay. The grandmother had a lot of 51As filed against her, and there were concerns that she was allowing inappropriate people into her house, allowing inappropriate people to reside in her house. This is not something to be taken seriously if inappropriate people are in her house. And she didn't express an interest until she had all these 51As and had an open case with the department. And mother is a danger to the child in the home because the grandmother had many restraining orders against the mother, and she showed up once, more than once, tried to take child J from the grandmother. So grandmother was 63 at the time of the trial, so she's also not going to be strong enough to fend off mother. Mother is not the only danger to the child at the grandmother's home. Since child J, the fire department said, if a suicidal juvenile with a pair of scissors, and then another time he threw a chair at the grandmother, and another time he threatened to stab her, kill her, and kill himself. So it's not really a very good environment for a meek little 2-3-year-old, which she's not 3 yet, but.
Okay. So we come to the red light. So,
okay.
And I thank you all for your arguments. And the case is submitted. We'll conclude the arguments for today. Thank you to the court officers and the clerks, and we'll be in recess.